3. No, issue notice making it returnable on 28th of April 2023. As the respondent numbers 1, 2, 3, 5, and 6 are represented by their respective counsel, extra copies of the writ petition be served upon them within 3 days. Steps upon the respondent number 4 by way of registered as well as usual. The petitioner is further directed to take steps by way of dusty upon the respondent number 4 and file an affidavit of service on or before the next date. On the returnable date, the learned counsel appearing on behalf of the respondent shall apprise this court as to why the petitioner have not been paid the amount of rupees 2,73,276, which is the amount as area upon refixation of the salary as per the MACP with effect from 1/4/2016.
Five.
Anything else?
SC finance may be reflected.
Oh, that is what I forgot. That is the name of Mr. B. Gogoi be reflected in the cause list as appearing on behalf of the respondent number 5 and 6.
At number 5,
Yes, Mr. Tiwari.
My lord, in this case, by the earlier judgment of this honorable court, the medical officers homeopathy working under National Health Mission came to enjoy parity with medical officers Ayurveda.
Medical officer?
Ayurveda.
Okay.
So they enjoyed parity in the matter of remuneration. Now, subsequently, the medical officers Ayurveda sought parity with the MBBS doctors working under NHM. Again, the honorable court allowed that parity. Now, the medical officers homeopathy, they were out of the purview of that very particular judgment because now they are seeking parity. Because now there is a parity between Ayurveda and MBBS. Earlier, there was a parity between homeopathy and Ayurveda. They are all working under National Health Mission. My lord, the petitioners are medical officers homeopathy.
Homeopathy. So you want parity with MBBS?
Working under NHM.
There is a matter pending that before the decision? That matter where 3 homeopathic have amalgamated.
yes.
That
This is not
aspect.
state government, this is NHM.
Oh, this is
And they are claiming AICT pay scale.
they are.
In those
No,
cases.
that's
Oh,
a
that is a
different thing.
different.
AICT pay.
Heard Mr. P.K. Tiwari, the learned senior counsel, assisted by Mr. A.R. Gogoi. Mr.
I pay for all. I'll pay for all.
Mr. B. Gogoi appears on behalf of all the respondents. Mr. Tiwari, isn't it this the case where all are asking for their individual payments to be increased?
That's a fixed remuneration. Madam. Remuneration is fixed because they are working on contractual basis under NHM. Since
So everybody's entitlement is separate and distinct?
since the question of Article 14 comes in, there is no intelligible differentiation, the rational and the objective criteria for making this distinction between the medical officers homeopathy vis-a-vis the medical officers MBBS or medical officers Ayurveda. So, my lord, on the question of parity, they have come because they constitute a class by themselves. They constitute one homogeneous group.
Then why have you made everybody a party? You should have made only one petitioner would have
Lord,
been
it
enough.
could have been a class litigation, yes. It could have been a class litigation, but my lord, the practical difficulties, my lord, understand Because if only one comes in, it happens, my lord, in many cases, the government takes a view only one came, the rest were the fence sitters. So, my lord, they have come collectively, forming one homogeneous group.
So you have to pay the court fee.
My lord, my lord, consider that we may pay, my lord, if need be.
You have
Yes,
to.
under the rules, yes. Under the High Court. My lord, we will pay the court fees then.
Taking into
Yes,
account that the claim of the petition, each of the petitioners to pay parity with the medical officers, MBBS,
Yes. Ayurveda, my lord, we would use.
with
the word.
Ayurveda. This court is of the opinion that the claim of the petitioners are individual. Taking into account the same. Taking into account the same. As it appears that there are 119 writ petitioners, but the court fee of only one person, writ petitioner, has been paid. It is required that all the writ petitioners pay their court fees. Accordingly, Mr. P.K. Tiwari, the learned senior counsel, submits that he would instruct his junior counsel to take appropriate steps for payment of the deficit court fee. Issue notice, making it returnable on when?
Well, after 4 weeks, sir.
Making it returnable on 3rd of May, 2023. As the respondents are duly represented, extra copies of the writ petition be served upon Mr. B. Gogoi within 3 days. On the returnable date, on or before the returnable date, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 shall file their affidavit.
6,
May I pray your lordship?
Hmm.
Matter pertains to AR salary. Similarly situated cases by learned single bench and division bench
Where?
is allowed. My lord, it is annexure
The
14.
release of the area salary of the petitioner and process the same for the period from so and so, and after quantifying the same, make such payment with bank interest. Oh, that is the only prayer.
My lord,
And
if your lordship gives me some time, I will go to the fact.
why do you need the facts?
Yes, lordship, I was appointed on 6th of October 1998, annexure 1, page 31.
Why did the area salary happen?
Oh, my lord, I was wrongfully terminated, and Honorable High Court subsequently interfered that order. Kindly, I along with similarly situated other petitioners filed writ petition.
Hmm.
My name appears at kindly come to page 40, page 50. Yes, just a moment. Kindly come to page 59. I am Purnima Das,
Yes.
Purnima Deka,
Ah,
and hide the judgment. Kindly come to page 66. 1/8/2013.
hmm,
My Lord Justice Rishikesh. Kindly come to the operative part,
hmm,
page 70,
hmm,
paragraph 15 and 16.
hmm.
So therefore, it is apparent that the affected person did not have any opportunity to defend their cause, and therefore their termination was not through a legally permitted process. And subsequently, my lord, de novo proceeding was directed to be carried out. And kindly come to page number 71.
So your termination from 21/5/2012 was interfered with.
Yes,
Okay, then
And,
you were reinstated when?
Reinstated, kindly come to page 72.
72.
Reinstatement 71. Bottom, below,
Okay,
annexure 6. In view of the above. May I?
where's your name?
My case number is here, WBC number
Okay,
3113.
okay. So 18/1/2014.
Yes.
And when did you get your salary from?
Salary,
From 18/1/2014.
yes, 18/1/2000, 21/5/2000, for 12 to 18/1/2014, I have not been paid.
So that is the salary you are asking for.
Yes, yes.
Very well. Now why? What has happened?
By that,
Representation has been submitted.
Yes, representation has been.
And what
submitted.
have they done?
They have not done nothing. Representation is at page number,
I have seen it.
yes,
Now you are entitled to that.
yes.
Now,
Division
what has
bench
happened
judgment.
to,
My
why
lord,
this matter has gone to the division bench?
some other petitions, some petitions were allowed, some other were not allowed, dismissed.
Hmm,
They kindly come to page 106,
hmm.
annexure 14. This Dipali Burman is same with me. She also filed a writ petition in the my lord Justice Rishikesh Roy's judgment reflects it. Record is that. So kindly straightway come to page 109. Honorable Division Bench with that Division Bench judgment. Jaichand Saini versus Union of India. 1969, 3 SSC 642.
Yes,
If your lordship wants to discuss,
I've got-
I have nothing to say.
Let me issue notice, madam.
we have spoiled so much of time only for issuing something.
Yeah, after your lordship, I will not.
My lord, because what has happened in case of the petitioner, just I want to offer an instruction.
The question is whether you have paid her the salary for that week.
Yes, yes.
No,
To verify that,
not paid.
if you have not paid, pay. Attend,
I am a heart patient, my
My
lord.
lord,
your
Because
heart
this-
patient would not affect them to verify.
whether my lord, she is similarly situated with MS Dipali Burman or not, that also I have to obtain instruction, my lord.
Oh,
Because she is relying
record says-
on this division bench judgment, my lord.
No, the question of the fact that Dipali Burman was also a person who was terminated
Yes, ma'am.
yes.
and who was also reinstated on 18/1/2014. There's no doubt.
Yes, ma'am.
Because if you see the judgment of the division bench at paragraph number 14, page 111, it is the same paragraph 15 and 16 of Justice Rishikesh Roy's judgment have been extracted.
Dipali Burman's name appears at page 46.
Then paragraph number 15 at page 112 shows that the termination order was held to be passed not through legally permitted process. It is pertinent to note that the inspector of schools might also inform the principal of the school in which the appellant was serving that the petitioner as well as similarly be again taken back into service and were permitted to resume their duties to complete the process de novo proceeding as held by this court, and admittedly thereafter the appellant was permitted to resume. That the single judge had committed an error in coming to the conclusion that the appellant did not challenge the order of termination dated 21/5/2012. It is also an admitted position that after considering the reply given by the appellant to show cause issued by the respondent, the competent order has come to the conclusion that the order of EI is not proper. Thus, the service of the appellant from the date of her service in the school in a way recognized. It also clearly appears that in a similarly situated case of Fakhruddin, who was the petitioner in so and so, have been granted similarly leave. Then, paragraph 17, the director is directed to take necessary for release of the area salary of the appellant and process the same for the period from so and so after quantifying the same, make such payment of the areas within a period of 3 months from so and so. Okay? You need to only verify as to whether the payment has been made or not.
Yes.
Or you want to take instruction.
I want to take interest because my lord, he has also not annexed the order of the single bench, my lord.
Yes.
Learned
it is-
single
it is
judgment.
attacked.
Which judge? That has been set aside. Why do you need that? No, Justice Rishikesh Roy's order is there.
That is there, my lord. In fact, thereafter, the Novo inquiry was done, my lord.
And,
in that
and kindly see page 71.
Yes, yes.
With reference to the above, I would like to inform you that while dealing with so and so, so and so, so and so, the Honorable observed that the impugned termination order was abruptly issued against the petitioner by the then heir. Therefore, it is apparent the affected did not have an opportunity.
Yes.
Directed the said order to start de novo proceedings against the teachers, and it is also directed to, and it is noted that the consequent upon a termination, the petitioners are no longer in service, but the Honorable directed to proceed against the petitioner for which the petitioner may be presumed to have been in service as earlier. It perhaps not legally permitted to draw department against a person who is not in service. The petitioner was communicated about this thing, seeking instruction as so and so, directed by so and so above, and in order to enable to start the heir, petitioners may be presumed to be in service insofar as the termination order of the petitioner is concerned as per the Honorable High Court's order, and so long as the final decision is taken on the de novo proceeding. Under such circumstance, in order to avoid further legal error, you are directed to make necessary in regard to allow to resume in year so and so till final decision is taken. So this period is taken as period on service.
Yes, madam.
And that is what he is asking for. And what is this repetition of the petitioner, which is there at page number 61? Where is it?
Page number
Page number 59.
59.
3113 of
Yes,
2012
Purnima
That is against
Taka
termination, my
and
lord.
Deepali Verma's name is
And-
at page 46.
and 3113 of 2012 is there at page
Yes, yes.
71.
Yes, 311. And de novo order is at page 89 onwards, annexure 10. Everything is there.
Page
Page 89, my lord, annexure 10. The de novo order. All page.
where is your name?
My name appears at
Page 92,
page
my lord.
92. Purnima Taka, serial number 6.
Considering the fact that other teachers, including 4 terminated ones from the same select list, are now in service and entitled to all money as per the High Court order in their force, depriving the 9 terminated petitioners current will amount to discrimination and subject to the condition that the amount paid to be paid as salary of other students shall be recovered from them in case of the decision of the higher authority for termination in turn. All the petitioners so are allowed to draw current salaries from the date of resuming of service in so in line with the similar. This is issued in compliance with the order dated demand passed in and other events.
I am Purnima Taka, serial number 6.
Then why is the petitioner not entitled to?
Then, my lord may pass a direction to verify us. I will verify it. If she is entitled, my lord, we will pay, my lord.
3 months. Yes, your name. I come
R.
back
Islam.
in 5 minutes
R.
and
Islam.
dispose of your
Lordship,
matter.
Lordship, as per you.
কোনো কারণে
Assisted by SK Das.
You are senior counsel?
No,
Okay.
I'm
Then
not
we'll limit it
designated
to
as
your
it.
R. Islam. Or Mr. R. Islam, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Katonia appears on behalf of the respondent number 134. Mr. B. Gogoi appears for the respondent number 2 and 5. Taking into account the facts involved, the instant writ petition is taken up for disposal at the motion stage itself. The case of the petitioner herein is that by an order dated 21/5/2012, her service was terminated by the Inspector of Schools NDC. Subsequent thereto, the petitioner filed a writ petition challenging the said termination order dated 21/5/2012, which was registered and numbered as WPC number 3113/2012. This court, by the judgment and order dated 1/8/2013, in WPC number 3113/2012, along with various other writ petitions, set aside and quashed the termination order dated 21/5/2012. In doing so, this court made the following observations in paragraph number 15 and 16, which is extracted here in under page 7. Thereupon, while an order dated 18/1/2014, the Inspector of School, NDC, directed the principal oblique headmaster oblique superintendent of the respective schools to make necessary arrangement to allow the petitioner along with others to allow the petitioner in the school so as to enable to complete the process of de novo proceedings till final decision is taken thereon in compliance with the directions passed by this court in the judgment and order dated 1/8/2013. Subsequent thereto, while another order dated, another communication dated 23/2014, the Inspector of Schools, Nalbari, asked the petitioner to show cause as to why the petitioner's appointment shall not be declared illegal and void, and accordingly, her service shall not be terminated. The petitioner, upon receipt of the said show cause notice, filed the show cause reply. It further appears from the records that an order was passed on 24th of March 2015 whereby the petitioner was allowed to draw current salaries from the date of resuming duty in the respective schools in line with the similarly situated teachers till final decision is taken by the higher authorities. As the period during which the petitioner was terminated has been treated to be on duty by the order dated 18/1/2014. Similarly situated persons like the petitioner have moved writ petitions before this court. Amongst them, one is WPC number 1030/2016 by one Fakar Uddin Ali Ahmed and another Ali Ahmed. This court, by an order dated 4/1/2019, taking into account of the same, directed the Director of Secondary Education to take necessary steps for release of the area salaries of the petitioners therein in compliance with the earlier directions of this court. The process which also appears to have been started by communication dated 15/9/2014 and 16/9/2014 for payment of area salary. The area salary to the petitioner was also directed to be released within a period of 3 months from the date of the said order. It further appears that the petitioner had also submitted representation seeking release of the area salary for the period from 21/5/2012 to 18/1/2014, which was set aside by this court by the order dated to 18/1/2014. That is the period during which the petitioner was terminated, which was set aside by this court by the judgment and order dated 1/8/2013 in WPC number 311P/2012. However, the said representations have not been addressed to by the concerned respondent authorities, for which the petitioner has again approached this court. The learned counsel appearing on behalf of the petitioner have further drawn the attention of this court to the order dated judgment and order dated 23/9/2022 in writ appeal number 211 of 2019, which is an appeal filed by a similarly situated person like the petitioner, wherein the division bench of this court, after taking into consideration the facts which are similar to the present one, at paragraph number 17, directed the Director of Secondary Education, Assam, to take necessary steps to release the area salary of the appellant therein and process the same for the period from 21/5/2012 to 18/1/2014, and after quantifying the same, make such payment of the area salary to the appellant therein within a period of 3 months from the date of receipt of the certified copy of the judgment and order. The learned counsel appearing on behalf of the Secondary Education Department had submitted that from the materials on record, it appears that the facts appears to be similar, but however, there is a requirement to make necessary verification as to whether the petitioner is similarly situated to the appellant in writ appeal number 211 of 2019. He therefore submits that instead of passing a direction upon the Director of Secondary Education to make payment to release the area salary, a direction may be given to make verification and thereupon, if found, then to pay the arrears salary. Taking into account the same, the above submissions made by the learned counsels for the petition parties, as well as also upon perusal of the materials on record, this court is of the opinion that interest of justice would be served if a direction is given to the Director of Secondary Education, Assam, to verify as to whether the petitioner is similarly situated with the appellant in writ appeal number 211/2019. And upon verification, if it is found that the petitioner is similarly situated, the Director of Secondary Education is directed to take necessary steps to release the arrears salary of the petitioner for the period from 21/5/2012 to 18/1/2014, and to make payment of the arrears salary to the petitioner. Full stop. The entire exercise be carried out within a period of 3 months from the date a certified copy of the instant order is served upon the Director of
Thank you.
Secondary Education. With above, the instant petition stands disposed.
Obliged.
Item number 7,
Deeply obliged.
May I please, your lordship.
Yes,
My lord, the petitioner is a retired company secretary.
minimum of pay scale.
No, my lord.
What do you want?
My lord, full pension, my lord.
Full pension. Why?
Petitioner appointed in my lord 1960 and retired on 2002. He had rendered more
You
than
were appointed when?
1960.
1960.
Yes, your lordship.
And
Retired on 2002.
then
Then, my lord, he had rendered more than 41 years of service. But his service was deducted 14 years from the gross period. Then come to his service period considered 26 years.
Hmm.
So, my lord, it is 26 years less than the full qualifying period. My lord, it is 33 years requirement. So, my lord, this deduction is illegal. Kindly see, my lord, impugn order, my lord, page, my lord, 57.
fifty.
57, my lord. 57.
Hmm.
My lord, Shamsher Ali, the petitioner,
Hmm.
Gram Panchayat Secretary 2. Then my lord would come to my lord
Date
serial
of
number,
birth, so and so, date of appointment. so and
date
so,
of appointment to-
retirement, so and so, class of pension, superannuation, gross service, so and so, non-qualifying, so and so, net qualifying, 26,
26.
average, monument, so and so, last pay, drawn, amount of pension, and so. Now you are getting your pension,
yes, your lordship.
but less.
Less, my lord.
You should
Because
have got more.
Yes, your lordship.
You say that the 14 years, 7 months, 4 days couldn't have been deducted.
Yes, your lordship.
That is your
Yes,
case.
your lordship. Because my lord, the full pension is average of the 50% of the average.
So you want the
pension.
full pension.
Yes, your lordship.
It is not the case that you have not received the pension,
Yes, your lordship.
but
I
you
have-
need the maximum,
yes, yes.
which is available.
And the one already decided this, another case, my lord, pays my lord, pays my lord 60.
Yes.
My lord, 72 pays, para 8, my lord,
Right.
para 8. May I read, my lord? Then would come to para 10, my lord. And
But Mr. Council, I think we should issue notice.
My lord, is a kapar case, my lord. Is a division bench already, my lord, held at the, from the date of initial appointment. Kindly see,
Where is the division bench judgment?
my lord, kindly see, my lord, the page 23,
Page
23. Page 23, 23,
23.
23. Page 29 is the, my lord, the starting judgment order dated, my lord, the 24/3/2010. 29. And operating party is page 50, my lord.
850.
Page 50, 50. My lord, last sentence, my lord. Last sentence,
Whereas on the other hand, it would be that the legislation is.
from the date of initial.
So page 53,
My lord. Is a notification issued by the, my lord, government, my lord, pension department.
so there it says, now in terms with the judgment referred above, the governor of Assam is pleased to order that the benefit of the provision of the Assam Panchayat so including stick for pension and other retirement dues applicable to the state government employees to be applicable to the provincialized so who were in service on or after remand on the basis of the length of their service reckon from the date of their initial appointment in the service of the panchayat.
Yes, your lordship. Because my initial appointment is 1960, my lord.
So from there,
Yes, your lordship.
so do you want this one?
Yes, your lordship. And the division bench judgment has already attained finality because,
I've seen
Uh,
that.
my lord.
Now, but you have been given only this.
Yes, your lordship.
When was this pension payment order passed?
Pension payment order passed in 2012, my lord.
2000?
12.
2012, and there they have not given you that.
Yes, your lordship. It approached my lord repeatedly. But denied.
Then what is this at page 66? Your representation.
Yes, your lordship.
You are still alive.
Yes.
And what is your age?
Is my lord
78.
78.
Will issue a short notice.
My lord, another judgment, your lordship, where my lord deduction was
Understood,
deducted.
whatever may be, will issue a short notice. I can dispose it off,
My
but
lord,
why? You want to say something, I suppose. Huh? Do you have anything to say?
We'll take
You see, the law is clear by the division bench. It has been categorically mentioned that it will be counted a person who have been working on or after some 91.
190.
The period will be counted from the service rendered from the date of the initial appointment in the panchayat. That aspect is clear, and you have also issued a office memorandum. So that is no, but here in this case, the petitioner have not been given, you have excluded 14 years or 11 years. And if he is given the 14 years, he gets full pension. I would have otherwise, in other cases, I would have, but take into account the petitioner is 78 years old. Should we delay the inevitable? What do you say, Mr. Goi, on humanitarian ground?
No, well, here Lordship
Should we
is given
delay the inevitable?
categorically in page 57, they have deducted is 14 years. So might be some reason, my lord, or my lord may not be. But my lord, that instruction will have to come from the director of health.
From director.
Yes. Only instruction, my lord, we will have to.
Yes, but because otherwise, your lordship, here everything, date of appointment 1960 is undisputed.
Yes.
As well as.
Why the deduction was made?
Exactly. your lordship.
So we get in next week. Third, Mr.
M. Islam. M. Islam.
M. Islam.
Right.
The learned counsel appearing on behalf of the petitioner. Miss,
And
so
Bora.
we need not disturb you much. It's Embora. Embora, no?
And Bora.
Embora. Appears on behalf of the respondent number 1,
4 and 6.
4, and 6. Mr. D. Bora appears for the respondent number
2 and 5.
2 and 5. Mr. B. Gogoi appears for the respondent
3
number
and 7.
3 and 7. At the issue notice making it returnable on 27th of March 2023. As the respondents are duly represented, extra copies of the petition be served during the course of the day. The case of the petitioner herein is that the petitioner was initially appointed on 2/11/1960. And thereupon he had retired on 28/2/2002. The gross period of his service is 41 years, 3 months, 26 days. However, how much? It is 14 or 11?
14 Madam.
However, while computing the pension by the Director of Pension, the period of 14 years, 7 months, 4 days have been excluded. And only 26 years, 8 months, 27 days have been taken into account as the net qualifying service. The learned counsel appearing on behalf of the petitioner has drawn the attention to the judgment of the division bench. In the case of division bench, in the case of the state of Assam versus Fazle Rabi, dated 24/3/2010, in writ appeal number 145/2009, whereby this court, the division bench of this court, categorically held that the benefit of the provisions of the, what is this act?
Assam Panchayat Employees Provincial Resident Act 1999.
So and so. Assam Panchayat so and so Act, huh? Including those for pension and other retirement benefits would be available to the provincialized employees in service on or after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment. The learned counsel has further submitted that in pursuance to that an SLP was preferred against the said judgment and order, which was however dismissed by the Supreme Court by an order dated 2/8/2010. Full stop. Subsequent thereto, the Commissioner and Secretary to the Government of Assam Pension and Public Grievance Department have issued a notification dated 17/3/2011, whereby it was categorically, it was mentioned that the benefit of the provisions of the Assam Panchayat Employees Provincialization Act 1999, including those for pension and other retirement dues applicable to the state government employees, would be available to the provincialized Panchayat employees who were in service on or after 1/10/1991 on the basis of the length of their service reckoned from the date of their initial appointment in the service of the Panchayat. The learned counsel for the petitioner submits that in spite of the said judgment of the division bench, as well as the notification dated 17/3/2011, the period of 14 years, 7 months, 4 days have been excluded while computing the pension of the petitioner and thereby depriving the petitioner of the full pension. Full stop. The learned counsel appearing on behalf of the Directorate of Pension, Mr. D. Bora, shall obtain the necessary instructions as to why the 14 years, 7 months, 4 days have been excluded while computing the pension of the petitioner. List accordingly. Liberty is given to the petitioner to mention the matter for upgrade. It,
Highly obliged, your lord.
yes, Mr. Sheikh.
My junior is doing.
Huh?
My junior is doing.
Okay.
May please your lordship. Lordship petitioner was working as sale assistant in the ASIPC lordship.
You have been suspended.
Lordship by the order dated 37/2022
30/10/2000
lordship. At
shall
30
not be issued to reinstate the petitioner with effect from by setting aside the impugned order dated issued on so and so. Now, what is your prayer, madam?
For setting aside the suspension order lordship and to reinstate the petitioner in his post.
Okay. What is your ground for setting aside?
Lordship till then more than 7 months have passed lordship. Without
You have not been given the charge sheet? Oh,
charge-
yeah, the charge sheet is here there.
Lordship, no reason order of extension was passed and review was not done, Lordship.
Oh, no review.
Lordship. This point already decided in the case of Lordship Supreme Court, Lordship in the case
No,
of
here the charge sheet has been given to you
Lordship.
on 19/10/2022. Then
Lordship.
subject show cause with reference to, I would like to inform that I have received the show cause notice with reference. I would like to inform you that the reply to the show cause would require some documents to be submitted along with the reply which I could not collect. Okay, then you submitted the reply on 21/11/2022.
Lordship.
Then
Inquiry officer was appointed Lordship. case
pending
for-
drawal of departmental proceeding is placed under suspension on 30/7/2022. Then, with respect, I would like to say that under suspension as per the rule of Iman was already paid to me after passing on Iman. There, as per the rule of the Iman is to be paid, but I have been deprived. Moreover, it is informed me that I came to know that those of it only after the. So you have asked for this. Then.
Inquiry officer was
Yes, Mr. Kohli.
ASIDC council will have to, let's say, there is a standing council for ASIDC.
Where is he?
I don't know.
His name has been shown.
I think his name hasn't been shown. His name hasn't been shown, I think, in the process. No, he
Who is the
has-
counsel for ASRDC?
Earlier it was Parangam Goswami, but later on somebody else has been appointed because in another matter.
Has their name
Yes,
been
yes.
shown in the cause list?
Causeless, it hasn't been shown.
Only state.
Only standing, no, it hasn't been shown.
Huh?
So they have a standing council.
Have you served a copy upon them?
Lordship.
whom?
Before filing,
Whom did you serve?
I don't know what to say.
এই কোনো তখন তার পরিচালনা নোটিশ। No, you have not served. You have only served to Mr. Kolita.
then it's
You want to serve, I suppose. Or do you want to, I issue notice, but that will take long, no? So I'll better you serve it.
today itself. We will serve by today.
Miss, your name?
F in touch.
Hmm?
F in touch.
F
In touch.
in touch. Appears on behalf of the petitioner. And Mr. A. Kolita appears on behalf of the Industries Department.
That's one number one.
Respondent number 1. The learned counsel for the petitioner submits that she has come to learn that there is a standing counsel for the respondent number 2. However, no notice have been served upon him, upon the standing counsel, and as such request for an accommodation for 2 days. Let the matter be listed on 27th. In the meantime, the petitioner shall take steps for service of the notice upon the counsel for the respondent number 2.
Problem.
Night. Yes.
Matter pertains to non-payment of arrear. Petitioners were employees of Assam Plantation Forest Development Corporation. And we are
Assam
agreed-
plantation.
We are agreed by the impugned letter issued by the managing director, that is on page number 25. Whereby we were informed that the corporation is not in a position to pay our arrear due to the poor financial
I
condition.
will issue remand the unpaid salaries of you and 3 others amounting to March. The corporation not in a position to pay the fees for the- Where as per the purpose instruction to the oil. Yes, madam, you are paying for?
For soil conservation, my lord, respondent number 1, 3, and 4, my lord.
Oh, what about the Assam Plantation Corp?
My lord, what happened, my lord, this writ petitioner number 1, my lord, he have also filed another writ petition, my lord, that is still pending, my lord. And he-
Regarding the same relief?
yes, my lord, one of the same prayer, my lord, for releasing outstanding salary.
Oh.
And my lord, he,
Why you want to
and he have
file
not
twice?
mentioned, not said, he was suspended, my lord, with effect from 12/6/2019. And not a single whisper he has mentioned in the writ petition.
That's about my submission is that let's say one petition is pending, that is regard, we have sentenced the with my suspension order. That is my instruction. That is being
Suspension.
engaged, that is being
And one of the
read by
prayer,
the
my lord.
another advocate.
So I need, my lord, instruction, my lord.
No, obviously you will get instruction only. But madam, you are appearing for
For respondent number 1, 3, and 4.
1, 3, and 4. Okay, so you appear for this plantation corp.
Yes, my lord.
Yeah.
MD, my
And what about 5? 5 also?
lord. 5.
And there is a 5. At page 5.
Yes, my lord. 5.
What, Mr.
P. Bora Road.
B. Bora, the learned counsel appearing on behalf of the petitioner. Miss, your name, madam?
My lord.
Your name?
RS Deuri, my lord.
R.S. Deuri appears on behalf of the respondent number 1,
3, 4.
3, 4, and 5. Mr. B. Gogoi appears for the respondent number 2. Issue notice making it returnable on 28/4/2023. As the respondents are duly represented, extra copies of the writ petition be served within 3 days. The case of the petitioner herein is that the petitioner have not been paid the area salary. To the tune of rupees 5,34,268. That is it.
That amount was for 5 persons. We actually had 2 per petitioner.
How much?
So, petition number 1 is that the amount stands at 1,85,646. And for petition number 2, the amount stands at 1,47,432.
They have not been paid the outstanding area salary of an amount of rupees 1,73,070 and rupees 1,35,904 respectively for petitioner number 1 and 2. It is the case of the petitioner that the respondent that the respondent number 5 had issued a communication to the petitioner that on account of the present financial condition of the corporation, the said salary could not be paid. Being aggrieved by the said action on the part of the respondents of not paying this area salary, the petitioner has approached this court. The learned counsel appearing on behalf of the respondent number 1, 3, 4, and 5 shall obtain the necessary instructions in this regard and apprise the court on the returnable date. It further appears figure.
I'm okay.
Then, Madam, you have referred to a case, na?
Yes, my lord.
What is the number?
WPC number, my lord, 2388 of 2020.
List of instant repetition along with WPC number 2388
2388 of 2020, my lord.
2020 on the returnable date.
Item number 10.
May I please, Your Lordship?
Yes,
This petition is for releasing the pensionary benefit of the petitioner, madam.
what do you want?
Pensionary benefit, madam.
Why you have not been given?
My lord, initially I was suspended from my job. That is on 1/2/2022, my lord.
Hmm,
Thereafter, I retired from my service on 31st March 2022.
hmm,
Thereafter, my lord, after my retirement,
hmm.
the respondent number 2
Hmm.
appointed one inquiry officer and presenting officer, my lord. This
Hmm.
much only, my lord.
Hmm.
And that is, lordship will find at page 15, my lord.
Yeah. In
Basically,
exercise of the
lecture
power so and so are appointed inquiry officer and presented respectively in order to stop reading such submitted. Yes, then,
Subsequently, my lord, I have filed one representation that is at page 16, annexure 3, my lord.
then,
My lord, that was not considered, my lord. Thereafter, my lord, the petitioner filed one writ petition before this court, my lord, for setting aside the initial suspension order and for releasing of the pensionary benefit, my lord. The honorable court, my lord, observed that as the petitioner has already retired from his job, my lord,
payment of pensionary benefit, question of payment pensionary. Then what happened?
like, my lord, the learned court observed that as the petitioner has already retired from his service, my lord, there is no existence of this suspension order, my lord.
Huh?
And there is no existence of this suspension order, my lord. What you will find at page 22, my lord.
Very well. Then,
And for the service benefit, it was advised to file another petition. Accordingly, my lord, I have communicated the order of the learned court,
what
my
is the
lord.
present status of your departmental proceeding?
My lord, that is not known, my lord. They even did not proceed with the service.
Huh?
They even did not proceed with my pensionary benefit, my lord.
That will look into it. But have you got your provisional pension?
No, nothing, my lord. Since last 1 year, I am
Mr.
not
Sharma?
getting even single penny, my lord.
Why have you been so such
Lordship,
unkind to the
under
petitioner?
Rule 22, Lordship, he is entitled to that provisional pension, but most probably some communication gap is there, as because if your Lordship comes to next page, he has served this notice to the inserts SDO, Huzai Sankar, though he should have been approved the deputy
My lord,
commissioner.
I have,
In that case, Lordship, it would have been most
No.
probably because of this Lordship, in the proper hand, the order of this honorable
My
court
lord-
has not done. But now Lordship, as I have been told that they have sent this copy of this order to the this disaster management, the respond number 1, Lordship. It is sent now. Whether this pension can be given or not, like that, Lordship, regarding that instruction now.
Yes,
And second one, Lordship, before my learned friend starts, most probably my learned friend has to add finance and AZ. as the
yes,
respondent,
finance. Mr. Gogoi, please don't.
as
leave.
because it's a monetary. But
And-
he has not made party.
Is he why necessary?
Regarding the pension,
Director of pension? is there?
Director of pension gives pension to the PNRD department and provincialized schools only. The others part lordship. Huh? Yes, lordship. And other part lordship, the accountant general.
And which department you are?
Latmondal.
Revenue is by
Yes, I'm-
AG.
No.
Revenue by AG.
So AG has to be made a party.
No,
No.
yes, no,
No, AG has to be made a party.
no lordship. He has not made a part.
That's a different thing. But AG has to be made a party.
Yes.
And the director of finance
Yes,
and the and not the director, the secretary finance and the treasury officer.
treasury officer like, no? No, but accountant general will be required, lordship.
Accountant general and treasury officer. That is the
Treasury
only.
officer is not also required according to my understanding.
Finance, government in the finance department may made a party.
Hmm. And why have you made the all other people a party as regards your pension?
My lord, actually, in the initial case, my lord, this.
They were made a party that is
My lord.
copy pasting.
No, my lord.
Then
And the another thing is that, my lord, this order is still now,
you have not made
existence
the
at all.
necessary people a party. Why are you making the circle officer a party?
my lord, in this case also, this order dated G6/22 is now still existence. now.
3-6 is for, why you are asking for challenging 3-6 now?
My lord, actually, for that reason, perhaps they are not.
No,
What that reason?
he is entitled for provisional. lord.
No, 3-6 has no value now.
Yes, exactly.
Does it have any value?
No, my lord.
Why you are making the things complicated? You are challenging us, you have retired. So the suspension order has already lost its force.
Yes, my lord.
And what about the disciplinary proceeding? You get your instruction.
That I have to obtain instructions, lordship, but I have no knowledge.
Yes, your name,
B. Chanda, my lord.
B.
Chanda.
Chandan, appears on behalf of the petitioner. Mr. H. Sharma
2 to 7.
appears for the respondent number 2 to 7. Mr. S. Dutta appears for the respondent number 1. Upon hearing the learned counsel for the parties, it appears that without the finance department as well as the office of the accountant general being made a party, an effective writ cannot be issued in the instant proceedings. Consequently, taking into account that the instant matter pertains to pension, this court adds the commissioner and secretary to the government of Assam Finance Department having his office at Dispur, Guwahati 781006, as well as the office of the accountant general having its office at Moidamgaon, Guwahati, as the respondent number 8 and 9 respectively to the instant writ petition. Mr. B. Gogoi, where is there an accountant general counsel? No accountant general today. Mr. Gogoi, did you see any accountant general counsel today? Mr. B. Gogoi, who is and so, who were present in the court, have accepted notice on behalf of the newly implemented respondent number 8 and 9 respectively. To issue notice, making it returnable on 26th of April 2000. The registry is directed to make necessary correction in the cause title. Issue notice, making it returnable on 3rd of May 2023. The case of the petitioner herein is that a departmental proceedings was initiated against the petitioner at a time when the petitioner was in service. At that relevant point of time, the petitioner was also suspended by an order dated 3/6/2022.
Suspended 1/2/22.
Huh?
Suspended by order dated 1/2/22.
1/2/2022. Thereupon, the state departmental proceedings, in the state departmental proceedings, the proceedings pursuant to filing of the show cause reply. You filed your show cause reply?
My lord, I did not ask for filing any so-called reply. No proceedings, just only this letter only.
Have you been issued any memorandum of
No,
charge?
nothing, my lord, nothing, my lord.
Pursuant thereto, it further reveals from the records that by an office order dated 3/6/2022, an inquiry officer as well as the presenting officer was appointed. It is however stated by the learned counsel for the petitioner that as on date, there has been no memorandum of charge, charge sheet submitted, served upon the petitioner containing the definitive charge on the basis of the allegations as is required under Rule 9(2) of the Assam Service Discipline and Appeal Rules 1964. The learned counsel further submitted that in absence of the memorandum of charge the charge sheet being submitted, the appointment of the inquiry officer as well as the presenting officer, which is done in terms with Rule 9(4) and Rule 9(5) of the rules of 1964, is completely contrary. In as much as without considering the written statement, without considering the statement of defense, without a memorandum of charge in terms with Rule 9(2), as well as the statement of defense being considered, the question of appointment of an inquiry officer as well as the presenting officer does not arise. Be that as it may, it is the further case of the petitioner that in the meantime, the petitioner have already retired and he has no further information as to whether the said proceedings have been, said departmental proceedings have been continued in terms with Rule 21 of the rules of the Assam Service Pension Rules 1969. The learned counsel further submits that the petitioner had retired on
31st March 2022, madam. 31/3/2022.
31/3/2022. But till date, the provisional pension as well as the DCRG, provisional DCRG have not been paid, which is the mandate of Rule 22 of the rules of 1969, as well as the office memorandum dated 21/6/2012. Taking into account the state the learned counsel appearing on behalf of the respondent shall obtain instructions, and respondent number 2 to 7 shall obtain instructions as to whether the departmental proceedings, as regards the fate of the departmental proceedings initiated against the petitioner. Further to that, taking into account that the rules of Rule 22 of the rules of 1969 and the office memorandum dated 21/6/2012, which categorically mandates that upon retirement of the petitioner and pending the issuance of the final PPO, The government employee is entitled to the provisional pension. This code therefore directs the respondent authority to take appropriate steps to forthwith release the provisional pension to the petitioner. Who appears for AG?
A Hassan, madam.
A Hassan.
Otherwise present.
Yes, some name may be recorded.
A Hassan, huh? Give the copies.
Lordship, Lord. Hello.
And number 11 and 12 for admission.
Yeah, please, sir. Let's pick item number 11. As our lordship is leading by Mr. T.J. Mahanta, Senior Township. He has left the court from some urgency. His father has been admitted in the ICU.
What is it?
Lordship is a matter of the.
What happened to 11?
Sorry,
What are you saying? I can't hear you.
my senior has been left the court. Some medical emergency. His father has been in ICU.
Okay. Mr. TJ Mohanto.
Yes, Lord.
Yes, what is your instruction, Mr. Bodley?
Lordship, I have received the instructions. Now the Lordship, the petitioners before your Lordship are casual workers.
Ah,
And upon liquidation, they have been paid their respective shares, your Lordship.
Hmm?
Upon liquidation, your Lordship, they have been paid, your Lordship.
ah.
So now as on date, there is no such year by the government to pay them.
Pay what?
Lordship, there is. Lordship may kindly,
What are they asking for? Will not be issued for setting aside and quashing the impugn order dated demand passed by the official liquidator Assam so and so. A reader should not be issued directing the respondent to release closer benefits VRS.
Right.
So your thing is the question of further making payment does not arise.
Lordship,
Any valid ground to release the further amount of rupees so and so to the petitioner.
Lordship, page 63 is the order. passed
I
by-
think, Mr. Bodler, don't you think that in view of that instruction, it is required to be put on affidavit?
Lordship,
Because now you are saying, totally denying that he is not entitled to any amount.
Lordship,
I think it's
I'll-
better you put it by way. of
Lordship,
We give you 2 weeks for that.
Lordship.
Mr.
T. Gogoi. T. Gogoi.
D. Gogoi.
T.
T.
Yes.
Gogoi appears on behalf of the petitioner. Mr. G. Bodler appearing on behalf of which department?
Corporation Department. Lordship.
Corporation Department submits that as per his instructions, the petitioners are not entitled to any other amount. Taking into account the same, this court finds it relevant, finds it appropriate that such instructions be placed on record by way of an affidavit so that the petitioner would be in a position to rebut to such statements. List the matter on 3rd of May 2023, on which day the respondent in the Corporation Department shall file their affidavit. The respondent in the Corporation Department shall file their affidavit by 26th of April 2023, and the petitioner, if so advised, would be at liberty to file their reply.
13.
Please, Lord.
Mr. PJ Soikia, in that matter, na, suspension,
My lord.
there are 2 orders you have challenged,
My lord.
if you remember. One is 23 and the other is the suspension. The suspension, I have given it from 23/1/2023 because that is the date on which they have served you that particular. So that is what. So not from 8/2, but from 23/1. That is one. And as regards the 23/1 so and so, I say that there is no illegality in that. There is no fatal, but they cannot proceed without issuing the memorandum of charge against you. So that I have made it, huh?
Right.
Because that was not argued.
Right.
But later on, when I was looking into it, I saw it.
Basically, the suspension order was selected.
But then also they may continue in the manner in which they have done it. So I said that without there being a memorandum of charge, which is required under 9(2), And there is a scope of defense because unless you know the charge, how can you reply? So that is there. But I say that appointment of a presenting officer or the inquiry officer is not fatal. But what is otherwise it won't be fatal, but they can't proceed without this. They can't proceed. Yeah. Yes, tell me. Good.
In this petition, my lord, the dependent father is before this honorable court, my lord, taking some relief on the, my lord,
Hmm.
death benefit of the son. What happened? in
What
this-
do you want?
my lord, what happened in this case, my lord, the earning son, my lord, was
Understood.
died in
Wait, wait,
117,
wait, wait.
2016.
What is your prayer?
Where,
We
my lord,
should not be issued directing the respondent nominee to provide some portion of debt cum service benefit due and payable to late Prasanto Soikia as per the order being the age-old parent fully dependent on the income of the deceased demand and the legal heirs of so and so on the basis of here. Now, who is getting the payment?
my lord, this is a wife respondent.
Who is
of
appearing
five,
for
my
respondent
My
number
lord,
5?
I am appearing for respondent of five,
Okay.
my lord.
So the CRG, that come retirement service benefit. You can't be entitled to family
lord. There is
pension, no.
There is no.
But the fact about the DCRG, would that person have got it when he would have been alive? Then why not? Share it.
My lord, the lump sum amount is lying pending, my lord. In the LIC, my lord, 4 numbers of LIC was the conduct, was in the name of the husband of the respondent of 5. Entire amount, 6,04,040,000 already received by the petitioner, my lord. Not a single penny provided to me, my lord. And here, my lord, about 2 lakhs. That amount also held due to this petition, my lord. So no pensionary benefit has been
Have you got
received, my
it?
lord.
6
No
lakhs from LIC?
service,
I have submitted additional.
No, you have got it.
My lord, I have got it, my lord. But entire amount has been, my lord, paid to the borrower, my lord. When the amount has been taken by the my deceased son. I have submitted the affidavit in reply, bringing all those documents.
that is not correct, my lord.
Why did you pay to the borrowers?
My lord, my son has taken loan from that person. Even car loan was from SBI. That amount, that loan amount was paid by the father, my lord, upon receipt of the, my lord, loan.
Show me where?
Additional affidavit will also be signed. Affidavit in reply, my lord.
Page.
Page 5 onwards, my lord.
Page.
Affidavit in reply. by the petitioner, my lord.
Affidavit in reply.
Yes, the file number 15/6/2018. Page 5 and
When
8.
did you file?
It was filed on my 15/6/2018.
15/6,
18/6,
2018. Tag B. Okay. What will be B? B. Eighteen six.
Yes.
Ah, of course.
Page 5 onwards, my lord. Original or annex?
How did you pay? How did you pay to that person concerned?
Well, upon
Of
receipt
1,50,000?
the insurance policy, the money from the
Understood, but how did you pay? You got that amount by way of check.
my lord.
How did you pay to this person, Umaron Soikia?
My lord, in case my,
Why did you pay in cash?
it does not know anything, my lord.
What do you know? You got it in check. These are all.
There are 7, my lord. I have categorically stated that.
Why these 2 lakhs was taken?
My son was taken that loan, my lord, before his marriage.
That statement, my lord, I am objected, my lord.
Which one?
This payment, my lord, regarding loan, my lord, the car loan in the name of the respondent number 5, my lord. Car purchased by me on the loan, my lord, that is counter affidavit is there, my lord.
Who is Prasanto Sekia?
My son, my
As a well express car loan.
Yes.
On 28/6/15 from Guwahati Medical College branch. And the loan has been closed on 10/8/2016 with full and final payment by cash transfer. Account number 20. So this amount is how much?
this, my lord.
There will be a bank certificate for that.
That was not with me right now.
Then why haven't you enclosed this? But how do this court believe these 2 aspects? Why didn't you pay by check or something? You got it by check. You got by way of bank transfer. Then why did you pay by cash?
That person, my lord, the person from.
Now tell me, this 2 lakhs was taken by your son. What is the proof of
I
that?
have given my lord the para 7.
No. What is the proof? There must be something written.
My lord, before his marriage, my lord, he took loan from that person, my lord.
But you have here it has been said that he has
Para
not
7
the
of my
1,50,000
affidavit
for
is
the purpose of purchasing a vehicle.
my lord.
What vehicle did he
That was
purchase?
also one of the, my lord,
What is the purchase vehicle he purchased?
my lord.
What vehicle did he purchase?
My lord, car,
What car?
my lord, Alto car. Alto.
Alto car. This is 1,50,000. And what was the State Bank loan?
This is the, my lord, loan
How much?
for the car, my lord.
How much?
Well, that I don't know.
Then
That is, my lord, I am clearing, my lord, that loan is in my name, my lord. I am purchasing car. That is Desire, my lord, Swift Desire, that is purchased by myself in that loan was taken by me, my lord, 6,10,000, my lord, on the installment, total installment, my lord, 84, my lord, that I annexed with my counter affidavit, my lord. Entire document I produced, my lord. These transaction, my lord, subsequently after filing this bank document, including loan document, these, I think how that document is prepared, he know very well. This document is prepared and filed subsequent. And from that LIC,
Mr. Sekia, your those 2 documents does not inspire confidence.
Originals are with me, my
So what? You also know, I also know. This doesn't inspire confidence.
personal loan, my lord. There's no written
Understood. The
document.
personal loan for what? For buying a car. When did the person die?
17/3/2016.
Huh?
17/3/2016.
He died.
My lord. Died in Thane.
And when did he buy the car?
That date, my lord, I do not know, my lord.
So this doesn't. And this is also doesn't show that the.
On 2 occasions, my lord, matter was sent for conciliation.
Huh?
On 2 occasions, my lord, matter was sent for conciliation for local. We present, but the response number time, my lord, not appear.
no. That is a false statement, my lord. I am appearing before the Luka Adalat, my lord, 2 times. This case is posted for Luka Adalat settlement before this Honorable High Court, but I appeared. The petitioner himself not appeared.
Mr. Sekia, I'm not satisfied.
Record will say, my lord. we will appear.
Records, whatever affidavit you have enclosed, doesn't speak. Because first of all, this person died in the month of
March.
March 2016. You say, when was the car purchased?
That date I do not know.
You don't know.
After the marriage, my
After marriage. When did he get married?
he get married in 2012, my
2012. And the loan was taken in 2015, November 2015. So when was the car purchased?
Well,
And which loan did you say? Because
That
this
car loan,
loan,
that car loan.
where you have said the amount is also not mentioned. You have purchased the Alto car. He says that it is a Desire car. Then
RCI annex, my lord.
There are 7 of my affidavits.
let her get the money. You file a civil suit. If you want to
There is
claim all this.
Another
thing.
aspect of the matter,
What is that?
the Pranam Act, my lord.
What is
says-
that?
It says, my lord. It says section 4, my lord. Pranam
Ah.
Act. It's
What does it say?
the-
We'll look into it. Second half. One lakh 50,000, as well as 2 lakh, 3.5 lakhs. And what about the other amount? Out of 6 lakhs, how much amount do you have received? You have received 6 lakhs, only 3.5 lakhs you have accounted for. And how much you have paid to the state bank? That is not mentioned.
Right.
Then
Give me some time, I'll produce everything.
no, what is that? It's court. You have not done it. This is matter has been going on from 2016.
My lord, only because my lord, the petitioner is not well, my
Hmm?
lord. Long back. He's not well, my lord.
Who?
The petitioner, my lord.
My lord, petitioner has another 3 sons, my lord. Another 3 sons is living, my lord.
My lord, they are not with us, my lord. They are not living.
Understood. They are government servants.
No, my lord. Daily wage labor, my lord.
And no, my lord, sufficient landed properties are there, my lord. They have.
And when did you get the amount?
My lord, in 2016, my lord.
16. Now you have paid only by transfer, discharge interest so and so. 3.5 lakhs plus another 1,22,000 you have deposited.
My lord.
Kindly come to page 5 of the affidavit filed by the respondent number 5. Now, Mr. Counsel, you have filed this affidavit.
My lord.
The deposit transfer is what? What is the page number 5
My
of
lord,
that?
it is dated, my lord, 26/7/2018, my lord.
Yes,
Here, my lord, it is the loan account, my lord.
yes.
Here, my lord, the
When did her husband die?
Husband died, my lord, 17/3/2016, my lord.
Now, how did this payment of 1,22,400 happen?
My lord,
Kindly see page 5 of your affidavit. The statement. There's a deposit of rupees 1,22,400.
it's my lord, credit her loan account, my lord, from her area salary, my lord. He's,
From whose area salary?
he is a contractual teacher, my lord. The respondent 5 is a contractual
Hmm.
teacher, my lord.
Hmm.
Primary teacher, my lord.
Then
That is, my lord, credited that account, my lord.
is this not the loan account? Is the loan account?
Yes, my lord.
So loan account, there is a credit of 1,22,400.
That is, my lord, some dues was available against her as because the regular salary.
Who paid this 1,22,400?
That is, my lord.
That is the main thing.
Yes, sir.
Whereas in your affidavit, you have said something else. Kindly see at paragraph number 7, where you admit that the loan which was taken was 2 lakhs. Against the loan he had taken, he had loan insurance against the said amount, and after the death of so and so, there was a clear balance amount of rupees 44,459. It was not 44,459. Only after clearing the loan insurance amount, and the said balance was paid by the petitioner on 10/8/2016, which clearly mentioned in the statement. Now, who paid this 1,22,400?
That's, my lord.
Petitioner paid my lord, page page 9 of my additional affidavit in reply. I have given the receipt.
Dated?
It was dated 10/8/2016.
Yes, that I see. So on this very day, another amount of 44,589 was paid. And thereby the loan closure had happened. So who paid these two amounts? 1,22,400 on 1/8. When did you get the money from LIC?
My lord, in the month of May, my lord.
So this amount is 1,66,000 plus 350. 450. 5 lakh. So 1 lakh you have. As per the records. You got 6 lakhs.
6,40,000, my lord.
6 lakhs 40,000. You have paid 1,50,000. 2 lakhs 350 plus 1,66,000. So 5 lakhs. So 1,40,000 you have. And she is entitled to these 2 lakhs. So you still have 1,40,000.
Since I am dependent on the income of my son, the Pranam Act, my lord, comes into play.
Pranami Act will only come in respect of salary. This is not a salary. Then how do you bring in? You still have 1 lakh. And what is the death benefit? Hmm?
My lord. The amount is my 2,22,000.
Total amount is 1,93,939,
Yes, my lord.
isn't it?
Yes, my lord.
Pay 50,000 from there. You remain, keep 150, remaining, let them 50,000, let it go to them. I think that is a win-win situation for both. Because you have already 1 lakh from there. So have 50,000 so that 43,000 and let her keep 150. Heard Mr. PJ Saikia, the learned counsel appearing on behalf of the petitioner. And Mr.
A.U. Ahmed.
A.U. Ahmed, the learned counsel appearing on behalf of the respondent number 5. And Mr. N.J. Khatonia
For 1, 3, and 4, my lord.
appearing on behalf of respondent number 1, 3, and 4. And Mr. B. Gogoi appears on behalf of the respondent number 2. The petitioner herein is the father of one Prasanta Saikia, since deceased. The respondent number 5 is the wife of late Prasanta Saikia. It is an admitted fact. What is your stand, the government stand? Is he entitled to this 1,93,000?
Yes, my lord.
Huh?
The area salary is entitled.
Huh?
For the area salary is entitled, she is entitled, my lord.
How much?
Amount is, my lord, 2,34,618.
2 lakh?
34,618.
That is the amount entitled to.
Yes, my lord.
It is an admitted fact that the late Prasanta Saikia was entitled to the amount of rupees 2,34,618.
618.
The dispute in the instant writ petition relates to a claim made by the petitioner that he should have a portion of the said amount which was payable to his son. It is also an admitted fact that the petitioner have received an amount of rupees 6,40,000.
276.
276 from the policies of the on account of being nominees to the policies of late Prasanta Saikia. The claim of the petitioner to have a portion of the amount of rupees 2 lakh so and so is being contested by the respondent number 5 on the ground that the petitioner have already received the amount of rupees 6,40,276. On the other hand, the learned counsel appearing on behalf of the petitioner have drawn the attention of this court that on account of certain loans which were taken, by his son, late Prasanta Saikia, the petitioner had to pay an amount of rupees 1,50,000 to one Jitu Boro.
Bora.
Boro or Bora?
Bora.
Jitu Bora. semicolon, an amount of rupees 2 lakhs to one Pradeep Mudoi, and a further amount of rupees 1,22,400 plus 44,589, which will be 1,66,989 to the State Bank of India, thereby totaling to rupees 2 lakhs, 1.5 lakh, 1,66,000, so and so. Upon hearing the learned counsels for the parties, a consensus has been arrived at that if an amount of rupees 50,000 is parted by the respondent number 5 out of the total entitlement of rupees 2,34,000, so and so, the petitioner shall have no further claim in respect to the said amount. The learned counsel appearing on behalf of the respondent number 5 have also agreed to part with the amount of rupees 50,000 upon receipt of the said amount from the government. Taking into account the said consensus, the instant writ petition stands disposed of. With a direction to the respondent authorities to disburse the amount of rupees 2,34,000, so and so, to the respondent number 5. And the respondent number 5, upon receipt of the said amount, shall within 15 days thereafter transfer the said amount to the petitioner. Good stop. With the above, the instant petition stands disposed.
Obliged.
19.
Yes, health is who? Yes.
Yes, my lord.
Finance is directed to obtain instruction as to what is the outcome pertaining to the government file dated so and so.
Lordship, I have received some instruction, Lordship.
Yes,
And
what is
so
it?
far as my instruction is concerned, the file was returned to the Health Department, Lordship, on 17/8/2022, Lordship. Thereafter, no resubmission of the file, Lordship.
I'll obtain instruction, my lord. Because now, just now I have come to know, my lord.
Mr. Counsel, this matter was taken up on 24/2/2023.
Yes, my lord.
This file was returned on 17/8/2022.
Yes, my lord. Because
Then
on that day,
why have you made that submission?
my submission as well as my affidavit is also there.
Is this court sitting out here to see both of you how the departmental
Lordship,
proceedings goes on?
What I'm submitting, Lordship, they have already approached the pay commission, Lordship. And pay commission rejected their suggestions, Lordship. And accordingly, they have taken a decision. Against that decision, we are reporting honorable court.
But whatever may be, there is a decision taken by the family, health and family welfare on 18/7/2020 that the issue pertaining to the post of staff nurse, same post, same pay, is under process through government file number.
Yes, my lord. Even an affidavit we have filed to that effect.
Then
That was prior to this date, Lordship. Prior to August 2022. Lordship. That probably that was the reason. Lordship.
Mr. P. Naik, appearing on behalf of the finance department, submits.
Lordship, I say I have received instruction. It was received on 17/3, Lordship.
That is what I am saying.
Lordship, I am filing an affidavit, Lordship, then they will obtain instruction.
No. I'm putting it. Mr. P. Naik, the learned counsel for the finance department, submits on instructions that the government file number HLA.959/16,
Actually, honey,
which was sent by the Health and Family Welfare A Department, was returned by the Finance Department. Pursuant to the observation of the Deputy Secretary to the Government of Assam, Finance (EC) Roman 3 Department, dated 8/9/2022. It was also mentioned in the order in the communication, interdepartmental communication dated 8/9/2022, that as regards the GP, what is GP?
Great.
Grade pay of the staff nurse, the Health and Family Welfare Department may take a policy decision and resubmit after discussion and incorporation of the same in the draft service rule. In that regard, Mr. Vinay had submitted a parawise comments which is kept on record and
Lot,
marked.
Lordship will grant me some opportunity to file an affidavit. Lordship, in the meantime, Health Department may be directed to.
I understand, which is kept on record and marked with the letter X. The Finance Department is further given the liberty to file an affidavit on the basis of such instructions so received. The Health Department, the Learned Counsel, Mr. D.P. Bora, appearing on behalf of the Health Department, shall obtain necessary instructions as regards what steps have been taken pursuant to the interdepartmental communication dated 8/9/2022, issued by the Deputy Secretary to the Government of Assam Finance EC Department. You want a copy of it? Na?
Yes, sir.
This I have kept it. Take a- List the matter again on how much time?
After 3 weeks, my lord.
Why? Let this matter again be taken up on 26th of April 2023. In the meantime, the affidavit, both the Finance Department as well as the Health Department shall file the affidavit. in the report.
Develop.
Number 20. Yes, Mr. Das.
Matter pertaining regular pensionary benefit.
We have resubmitted a pension proposal on 14th, madam, recently.
The Learned Council appearing on behalf of Mr. N.J. Khatuni, the Learned Council appearing on behalf of the Secondary Education Department, submit that the pension proposal along with the original service book of the petitioner
Petitioners.
and 8 other. How many petitioners are here?
Total 9 lordship.
Huh?
Total 9 number.
That is what petitioner
And
of the petitioners for regularization of the pension have been submitted to the Director of Pension on 14/3/2023. In that regard, a communication to that effect have been submitted before this court which is kept on record and marked with the letter X. The learned counsel, Mr. S.R. Bolwar, appearing on behalf of the Director of Pensions, shall obtain instructions on the next date as to what is the present status of the pension proposal so submitted by the Secondary Education Department. List the matter on 19th of April 2023. Mr. P. Nayak appears for the Finance Department. And Mr. Deka, what you,
Number 9, my lord,
who are you?
Indian Oil Corporation.
How is Indian Oil
It is,
Corporation?
the school is of the Indian Oil Corporation. The school was funded by the Indian Oil Corporation. Salaries were being paid, my lord, there is an agreement between the government. But now as per the latest meeting, my lord, the government is saying that the responsibility of pension is theirs, man.
Mr. Ndeka appears for the response number.
9. Obliged.
$25. Yes, PNRD.
Malad, I pray for two more weeks time, Malad,
For what?
to obtain these instructions, Malad. By the order dated 1/2/2023.
Mr. N.K. Devnath, appearing on behalf of the Panchayat and Rural Development Department. Submits that he requires a further accommodation of 2 weeks to take instruction in terms with the order dated 1/2/2023. Let the matter be listed again on 10th of April 2023, on which date the learned counsel appearing on behalf of the PNRD departments shall obtain the instructions without fail.
$31.
Lordship, I beg to mention for timing of the matter.
What is this time being business? In the second half, you have a time being business.
I'm sorry.
Mr. Chaudhary,
Yes.
there is one matter which one of your juniors
Oh,
mentioned.
yes, my.
We will close it. That
Yes,
is
my lord,
item number
let it go in my name.
47, because
Yes, yes, sir.
otherwise it
Yes,
is not there. Heard Mr. Kane Chaudhary, the learned counsel, senior counsel, assisted by so and so, who submits that in view of the fact that the petitioner has already been terminated, the instant writ petition has become infructuous. Accordingly, the instant petition stands dismissed as being infructuous. Item number 47, huh? Yes.
My lord, it's a case of suspension, my lord.
Ah,
If your lordships will kindly take note of the dates, my lord.
ah.
First, a show cause notice was issued on 25/3/21.
Hmm.
Then, my lord, suspension order is 8/4/22.
Hmm.
Thereafter, no review, no nothing. Proceeding is of course going on, my lord. That has nothing to do with here. The facts are peculiar, my lord. If you go by Ajay Chaudhary, the first party says that within 30 days charge sheet is to be given. Thereafter, my lord, review has to be done. Here, my lord, there was a charge sheet on 25th of March. Suspension is of 8/4/22. So, my lord, now review has not been done, On last occasion, my lord, my learned friend, Mr. Nath, I think perhaps said
Hmm,
that some inquiry is going on.
hmm. Now, he was supposed to, in fact, in the
Yes.
meantime, what happened?
Based on links in other court part, he has instructed that inquiry has been done and it has been submitted before the director on 17th of March. Inquiry report has been submitted now.
Let that go on, my lord. We have got nothing to do with that. We are on, my lord, the propriety of the suspension order.
But taking into account the inquiry report, if it has been already submitted,
Yes, my lord.
would it be proper to?
My lord, the inquiry is also expert,
It can't be
Actually,
ex
my
parte because he knew about it on the last occasion when Mr. Deka
Yes,
was
yes.
appearing.
No, I've seen that order, my lord.
Hmm.
Order says, my lord, DNAT learned counsel appearing on behalf of the respondent number
Hmm.
326 submitted that inquiry proceedings are going on at present against the petitioner, and petitioner has been asked to appear on 27 to 23 along with witnesses for further continuing with the said inquiry process. Accordingly, let the matter be listed on transcript. Now, my lord, after this inquiry report, maybe they will serve us a copy, then proceeding will take place.
But if the inquiry report is otherwise, would it be proper on the part at this stage to reinstate? Once, because the basic idea behind Ajoy Chaudhary is non-completion of the departmental proceedings. Now, if it has already been submitted, I can take only one thing, direct only them to immediately serve you the inquiry report. I think that would serve your
My
purpose.
lord, in my humble submission, my lord, apart from ensuring speedy trial, there is a procedural safeguards provided in the form of 90 days.
19?
That 90 days is a procedural safeguard, my lord.
Understood,
idea- the
but
whole
once
idea
the
is to-
departmental, you see, yes, departmental proceeding starts with the initiation of issuance of the memorandum of charges and ends with the decision in terms with 910. But it is at that stage where the inquiry has already been done.
No, my lord, here is a case. Admittedly, in March 2021, show cause notice was issued. Now thereafter, my lord, and the allegation is, my lord, I took 1 day's casual leave without permission. That is the basic allegation. Now, my lord, because my application was forwarded by the head, then thereafter at 11 o'clock, I left the college. That's the charge. Then, my lord, I was suspended on 8th of April 2021. Now we are almost more than 1 year. Even if the proceeding was going on, my lord, was it not incumbent on their part to review my, the suspension? Then, my lord, what meaning we give to Ajay Chaudhary, my lord?
If that be so, then why in Ajoy Chaudhary, in spite of the fact that the 3 months is the period and the memorandum of charges was submitted later on, after a long time, at paragraph number 22, the Supreme Court says that this the benefit of paragraph number 21 shall not be given to Ajoy Chaudhary. How do you take care of that?
No, if your lordship would kindly take the Ajay Chaudhary once, my lord.
Yeah.
Yes. Let us first come to 21 first, my lord. We therefore direct that currency of a suspension order should not exceed beyond 3 months.
Hmm.
If within this period, the memorandum of charge sheet is not served on the delinquent officer. The first situation is, my lord, if within 3 months of placing an incumbent under suspension, the charge memo is not given, then, my lord, he is entitled to that benefit. Now, second, if the memorandum of charge is served, a reason order must be passed for extension of the suspension. I am on this, my lord. Memorandum of charge has
No,
been.
understood.
Yes.
But what do you see?
Yes, now let us read it further, my
Hmm.
lord. As in the case in hand, the government is free to transfer the person concerned to any other department in any of its offices within or outside the state, so as to serve any local or personal contact that severe actually, any local or personal contact he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records or document till stage of his having to prepare his defense. We think this will adequately safeguard the universally recognized principle of human dignity and right to speedy trial, and shall also preserve
the interest of the government in the prosecution. We recognize that this is different aspect.
Now you see here in this case of Ajay Chaudhary, this person was suspended on 39/2011.
Yes, yes,
If you see the first line
yes.
of the judgment.
Yes, my lord, 3911.
And if you see paragraph 22, and the judgment was delivered on 16th of February 2015,
15.
after 4 years.
So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet. And therefore, these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and his action of respondent will be subject to judicial review.
That is the problem.
No, my lord. No, later line says, however, if the appellant is so advised, he may challenge his continued suspension in any manner.
Any other ground you have, you can.
No, my lord. Any other ground is our, my lord, departmental manual is set. It says the proceeding has to be concluded as early as possible.
Understood, but as early means they have already submitted. The inquiry report has
My lord,
already been
in fact, my
submitted.
lord, charge sheet was preceded by this, the charge sheet preceded the suspension. No, all-
Maybe,
my lord,
maybe, but whatever may be, as of now, the inquiry report has
No,
been
my lord.
submitted.
My lord, merely because, that charge sheet has been served, that does not mean they will take 3 years to conclude a proceeding. I'm giving an example. Is it permissible if we are to take the view which is lordship is expressing, then my lord, even if they take 5 years, there will be no problem because charge sheet has been issued.
No. If in the meantime, the basic reason, if you see the judgment out there, our Judge Chaudhary, is a person who has been kept under suspension and there has been a continuous delay in the departmental proceedings. In the instant case, on 17/3, they have already completed the departmental proceedings, may not be. The second stage of 311/12/2 is already there. That is another aspect of the matter. But otherwise, it has already been done, those persons.
No, my lord, I was only trying to read this placidum C of para 21. If memorandum of charge sheet is served, a reasoned order must be passed for extension of the suspension.
Then why didn't the Supreme Court then
Yes.
interfere and give the benefit under paragraph number 21?
The facts of this case, what Supreme Court has done is different. But while laying down the law, Supreme Court said 2 requirements. First, ideally, the charge sheet should be filed within 90 days. Even if charge sheet is filed, if it exceeds 90 days, then there must be a review, periodic review. So that's a procedural safeguard, my lord, which flows from this judgment in terms of Article 142. And therefore, my lord, that's what this honorable court has been enforcing. Now, what meaning we give to that second part, my lord? Yes, it's a fact. Their charge sheet has been issued. Despite difference of charge sheet, Supreme Court still mandated that there has to be a periodic review. No review has been done. So non-review, for example, I'll give an example, my lord. When Tata Act was challenged, in Qatar Singh's case, Honorable Supreme Court said Tata is valid. However, my lord, a procedural safeguard was given. In those cases where investigation could not be completed, therefore charge sheet not filed. And in those cases where investigation completed, charge sheet filed, but charge has not been framed, in those cases, my lord, Honorable Supreme Court said that there will be a committee of 3 persons comprising Chief Secretary, Home Secretary, and DGP, and they will review each and each case. If anybody's review was not done, my lord, they will be entitled to bail and other consequences. In fact, I won't name anybody, my lord. The benefit of that order was a present politician of government of Assam. So it's similar thing, my lord. It struck me. That's my only submission is, my lord. After issuance of charge sheet, there is a requirement of reviewing the suspension. Notwithstanding, my lord, what is the stage of, yes, in a given case where, my lord, the very next day charge sheet is issued, then, my lord, proceeding has, in a given facts of the case, writ of charge sheet, lordship may not be inclined to issue. That's a discretionary jurisdiction. But to say that because charge sheet has been given, I think that, my lord, lordship will have to consider that aspect. Yes, in a given case, a writ of charge sheet, lordship may not like to invoke because there has to be a failure of justice. But case of this nature, I think, my lord, the court has recognized the procedural safeguard. Now, how to, my lord, deal with that? I'm only on that. Because now if they say that the inquiry report is submitted, the director will issue a show cause, second show cause, or inquiry report, then there will be a, reply, then they will pass an order. It may take another 6 months. Maybe it may take 3 months. So that's why my humble submission, perhaps, my lord, I am entitled to this benefit.
Mr. Chaudhary, difficult.
I can only make my submission.
I can put it on some other date, but difficult.
Anyway, lordship will take it on another day, then let me try to persuade your lordship.
Because the paragraph 22 is the difficulty. And furthermore, if you see what has happened is this Ajay Chaudhary judgment has been before many high courts.
Yes.
In fact,
In
while
fact, my lord, we are talking of Ajay Chaudhary. Much before Ajay Chaudhary, there is a judgment called Deepak Mali,
yeah, I've been-
Union of India versus Deepak Mali.
Mhm.
Same quorum, my lord, 2 honorable judges.
But the thing is, there are many other judgments also. Although in Rekibuddin, our division bench have upheld the application to this. but
6-2.
there- 6-2 has been applied.
Actually, my lord, if your lordship kindly have a look at 6-2 and 6-5, even our rule does not make any distinction between 6-1 suspension and 6-5 suspension when it comes to revocation. Because 6-2 itself says, doesn't make any distinction. Only thing is that provisos, if the conditions are fulfilled, whether it is a suspension under 6-1 or a deemed suspension, the same consequences will ensue. Even and sub-rule 5 makes that position further clear.
Sub-rule 5 is
Yeah, lordship
parameter
has
to the CCS rules
that
of
finding
65.
of your lordship,
Yeah.
that if a person is behind the bar, where is the question of mistake? That is absolutely correct. That is, of course, nobody has, my lord, said before a lordship.
Yes, Mr. Nath, when you are serving him the order,
For the last, as per the last order, I got the status. The inquiry officer has submitted the report on 17th of March to the director.
then when are you issuing him a notice?
Now the director is to take up the director is the actor. And for the college authority.
Because Mr. Chaudhary's submission is categorical. Says that, you see, the departmental proceedings starts in terms with rule 9.2, whereby you have to give him a memorandum of charge containing the various
My lord,
specific charges
my lord,
along with the
I'm sorry
allegations.
to interrupt, my lord. Till date, I have not been communicated with any order that inquiry officer has been appointed. I think my learned friend has given a wrong information, my lord. He said inquiry by the college, not by the disciplinary authority.
Inquiry officer has been appointed, and I am told that the inquiry officer has submitted the inquiry report on 17th of
No, my
March.
lord, if an inquiry officer is appointed, then I'll get to know from a communication that so-and-so has been appointed as inquiry officer.
You have you intimated him about the appointment of an inquiry officer and the
Yes.
presenting officer?
Yes, yes, my lord.
I don't think inquiry has commenced at the level of directorate, my lord.
As per the director's order only, the inquiry officer has been appointed, and I'm told that the inquiry officer has submitted the report on 17th of March. That is my instruction, my lord, from the college authority. Well, Mr. Gogoi, he appears for the director. Lordship has recorded in the last order. We have submitted, and Lordship has directed us to take the status of the inquiry and to apprise the position today. So my position, according to my instruction.
Now, is this an inquiry in terms with the rule 9?
Rule 7, yes, under the 1964 rule.
So obviously you must have appointed as per rule 9 and rule 9.4.
Yes.
9.4 and rule 9.5, you have appointed the presenting and the inquiring officer,
Inquiry officer, yes.
and you must have intimated him
Without intimating him, cannot proceed.
Sure. No?
because Mr. Chaudhary's question is submission is this.
Okay.
That look here, the Ajay Chaudhary says two aspects. One, if you don't serve the memorandum of charge from the date of suspension for 3 months, then in that case, the currency of the suspension has to be interfered with. The second aspect is, even if you have served the memorandum of charge, then also it is there is a requirement for review, periodical review. In the instant case, there has been no review on your part. And as such, he claims that for purpose of reinstatement. Now, have you filed your affidavit?
But for the college authority, no, my lord, we have not filed.
I think
In-
my
in fact,
learned friend doesn't represent the director.
the
He's appearing
director-
for the college.
Yes, yes. my lord.
So
Understood?
I think he's referring to the inquiry by the college, not the
No, no.
inquiry by the
No,
disciplinary
no,
authority.
inquiry by the college was done long back. It was placed before the director. Thereafter, the director has taken the action. It was long back.
Have you filed your affidavit?
No, my lord.
My lord, can I make one suggestion for prayer matter?
Mm.
Let my learned friend place before this honorable court in the next week or maybe on Friday, the order by his inquiry officer appointed and that copy was served upon.
Yes.
And secondly, my lord, whether the disciplinary proceeding, as we understand in terms of rule 9 has been completed as submitted by, then everything will be clear. To our understanding, my lord, I have not received any communication regarding appointment of the inquiry officer. So therefore, there is no question of, attending any inquiry.
Have you communicated him? Have you communicated the petitioner that on such and such date is the date fixed for your coming with witness? Because you had made a submission on the last occasion.
Yes, yes, my lord. That was the telephonic instruction. I made the submission and my lord, for director, my learned friend appears. In fact, the order is there. We'll produce it, my lord. Logic is taking up the matter after 2 days or 3 days, my lord. We'll produce it.
What are you going to produce?
The order passed by the director appointing the inquiry officer and the inquiry officer's communication. In fact, I'm told that the report has been submitted.
No, the inquiry, a committee of the college has submitted a
No,
report.
That is
internal
the
committee.
that is the
yes.
preliminary inquiry, and on the
And
basis
on
of that, my lord,
28
the
we
matter
have
was
been
done.
served with this copy.
After that, inquiry committee was constituted, Lordship, from directorate level, Lordship.
Okay.
Director level. was constituted.
Yes.
Lord Mr. Kane Chaudhary, the learned counsel, learned senior counsel assisted by Mr. R.M. Dekka. Mr. K. Gogoi appears on behalf of the Higher Education Department, and Mr. D. Nath appears on behalf of the respondent number 326. Mr. Kane Chaudhary, the learned senior counsel, has submitted that as per his instructions, the petitioner have not been intimated about appointment of any presenting officer as well as the inquiry officer. He further submits that the petitioner have not received any notice for appearing before any inquiry officer. Is that your submission?
Disciplinary inquiry, my lord. For
Ah,
this inquiry,
disciplinary.
yes. One
No, that is a
preliminary-
different. For this,
Inquiry made by the college authority
I'm not here.
from the department I
Have you received any notice that to appear on 27/2/2023?
that notice we received, my lord. That notice we received that we have to appear before the inquiry committee on 27th. my lord. And on that day, this inquiry report was served upon us. Inquiry committee constituted by the college authority.
So you have received, and before whom did you appear?
Before the committee.
Where is that
constituted by
notice?
the-
Do you have a notice?
So the,
This
there was
inquiry
one,
report is with me, my lord. but
No, no, no. Do you have a notice
this notice right
Notice
now,
of 27, asking you to appear on 27/2/2023?
that we can take before lordship, my lord.
that instruction he had.
That protection I have, my lord, but notice, my lord, I can,
But you have not been asked to appear before any inquiry officer.
no. my lord. We are asked to appear before the inquiry committee constituted by the college authority.
On
On
27/2/2023.
27/2, we appeared, my lord, and on that day we served.
We are served with this
with
report.
inquiry.
It is by one Binoy Kolita, chairperson inquiry committee, Sangita Kakoti,
Okay.
member inquiry committee.
He further
Rosita-
submits that it will last line to give.
ये महिला
It will got you. It will not. It will got you. On the other hand, Mr. Dinath, the learned counsel appearing on behalf of the respondent number 3 to 6 submits upon instructions that on 17/3/2023, the inquiry officer, so appointed by, who has appointed?
For the director, higher education, by order dated 13/1/2023, appointed the inquiry officer.
By the director higher education, had submitted the report to the director.
Yeah.
Full stop. Taking into account the same, let the matter be listed again on 27,
27. Lordship.
27/3/2023. On which date? The learned counsel appearing on who? Who is going to read?
So I'll also put it.
How both of you? Do you have the still the control?
No, no,
Huh?
no, no, no.
How?
I think Mr. Gogoi would be in a better
Yes,
position.
I think Mr.
Lordship,
Gogoi on which date Mr. K. Gogoi, the learned counsel appearing on behalf of the Higher Education Department, shall produce before this court the communication by which the inquiry officer was appointed
Lordship.
by the Director of Higher Education, and as to whether there has been any communication pursuant thereto intimating the petitioner about such appointment. He further shall also produce such notices which were issued to the petitioner to appear before the presenting inquiry officer. Full stop.
Lordship, I have a pair in this case. Lordship, kindly reflect our higher education name, Lordship. Today, miss out the file also.
The registry shall also is directed to show the name of Mr. K. Gogoi as the standing counsel for the Higher Education Department in the court.
Pleasure.
Deep level.
43.
May I please, your lordship? Lordship,
Yes.
May I please, your lordship? Lordship, instructions are awaited, your lordship. We have not received the instructions.
Why? There is a circular of 21/7/2006. Where is that?
Lordship,
Circular 21/7/2006,
2016, your lordship.
2016, yes, where is it?
Yes.
21/7. Oh, this one.
Page 57, lordship.
Why should we shouldn't dispose of to make a verification and get it?
I will, this honorable court.
Give it to me.
Yes.
We dispose it of unnecessarily.
Lordship.
You have paid the court fee.
Yes, sir.
Good. Your name?
P. Zaman, lord. P. Zaman.
P. Tamang?
P. Zaman.
P. Tamang.
Yes.
Madam, you are the same
Lordship,
as
P.
earlier. You
Lordship,
appear for respond numbers?
1, 2, 3, and 4, your lord.
All.
Lordship.
Has been taken up for disposal. The case of the petitioner, he is the petitioner. Are your assistant teacher?
Assistant teacher. All are assistant.
Huh?
All are assistant teacher.
Having BA degree, they are also entitled to one advanced degree now. However, has been denied the learning council to petitioner has met. So that regard has found that having significant differences in between but to the order dated NP number 1, 2, 3. Yes. Dispose.
Obliged. Obliged.
I can do it. Huh?
Forty-four.
Yes, Mr. Bora.
Your Lordship, I have received the instructions.
Hmm.
Disciplinary proceedings have actually commenced.
What
has
is
not yet, the fellow- The para is
The fact that due to police case and custody of Iman was placed on the suspension pending trial. Fact that there was allowed to close the arrested by the police beyond 40. The DP is going on?
Yes, Your Lordship.
When did you serve the memorandum of charge?
Last page, Your Lordship, of the para comment.
Hmm.
Of the-
When was he released?
He was otherwise
Released on 12/3.
released on 12th.
Then
Then show cause notice issued annexure 5.
Annexure 5.
Then he filed a reply on 12/7 annexure 6, page 20.
Then he submitted a reply.
Then page 20.
Then
Then this particular the inquiry officer and just have to look. Then this by order dated 10/7/2022, the presenting officer and the inquiry officer were appointed of my instructions to the
10/7.
2022. That order is annexed with the parawise comment. Last page. Annexure. Thereafter, it is going on, but it has not yet concluded.
15 days was given on 5th of July. For 15 days, 15 months will be over. July, August, September, October, November, December, January, February, March. 9 months.
5th of July, he was directed to submit his reply. He filed his reply on 12th of July,
Hmm.
page 20.
Yes.
Thereafter, basically, the inquiry is going on, but certain documents are missing.
Hmm,
since the police investigation is also on.
hmm.
So that is why in the terrorist comment itself,
Now, have you reviewed it?
review, no, your lordship,
Why?
that is not done. I specifically inquired whether it has been reviewed in the meantime.
Then,
That has not, as per my telephonic instructions, but not written instruction, I have to obtain a written instruction to that effect.
hello, petitioner is not around. So this is given on 10th of March.
Yes, your lordship.
What was the reason for initiating departmental proceedings against him?
As per the annexure 5, he was actually, an FIR was filed describing that the accused Pappu Mazumdar and others hatched a criminal conspiracy among themselves and prepared a forged land sale deed of his paternal property by enticing his brother.
Of his paternal property.
Yeah, yes. During investigation of the above case, he was arrested and he was actually one of the person involved in forging that particular sale deed.
Have you paid the subsistence allowance?
Yes, your lordship. Page 18, annexure 4.
That is an order being passed, but have you paid the subsistence allowance?
Yes, yes. 50% earlier, now I believe they are going to increase it to 75%.
None appears on behalf of the petitioner on call. On behalf of Mr. D, the learned counsel, Mr. Deepora appears on behalf of the respondent number 2. The learned counsel, Mr. Deepora, submits that the petitioner was placed under suspension on 15/2/2022 pending broil of department proceedings. He further submitted that show cause notice was issued. And pursuant thereto, the petitioner had also submitted the reply. Thereupon, on 5th of July 2022, an inquiry officer as well as the presenting officer was appointed. He submitted that the present, although as per the order dated 5/7/2022, there was a direction to complete the inquiry and submit the report within 15 days positively. But on account of on account of the fact that the records relate to different officers, viz. Sadar Police Station, Settlement Office, Registration Office, etc. There has been the delay in the process. However, this court had made an inquiry as to whether there has been review to the suspension order. The learned counsel for the petitioner submits, respondent submits that as per his telephonic instructions, there has been no review. However, he would like to take concrete instructions in the matter. Let the matter be listed again on 27th of April, March 2023, on which date Mr. Debora shall apprise this court as regards the present status of the inquiry, as well as to whether there has been review in, which is the requirement in terms with paragraph 21 of the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary versus Union of India, reported in 2015 7 SCC 291. The instructions were submitted by Mr. D. Bora is kept on record and marked with the letter X.
We have got the proof for basically the postal receipt and the postal status report also, which says that he did not receive it. And even then also, this 15th or it was convened, but since he did not appear, again it is convened on this 27th of March. So he may appear now.
Well, first of all, the issue is when this charge sheet was issued, my lord, because we have not received, my lord. This is my categorical instruction from my client.
You have a copy of the charge?
I have a copy of the charge sheet as well as the WhatsApp status message, everything.
WhatsApp?
We have sent it to WhatsApp also. He did not even open the WhatsApp.
But I received hundreds of WhatsApp. I'm not going to open it unless the numbers are known to me.
No, the
March,
charge
yeah.
obviously not to you.
So this WhatsApp message is 4th March 23 and
This is the latest.
there are some correspondences which says which are dated 16th March 23 and they are not marked to me, my lord. I'm sorry, it's there. 16th March 23, my lord. And the suspension order is of
And that is immaterial. You got the charge sheet now?
My lord,
Matter and-
utmost respect, my lord. Ajay Chaudhary's case has two aspects, my lord. In fact, I was there when your lordship was taking up the other matter. In Ajay Chaudhary, my lord, there were extensions. In paragraph 6, it has been clearly said there are 4 extensions. Now, within the extension period, if a charge sheet is issued, it is understood. But you give a suspension order, you don't serve that upon us. After 2 years also, you don't give it. It's sometime in March, you will issue a charge sheet. That is not what the law says in Ajay Chaudhary, my lord. In fact, after Ajay Chaudhary, the government of Assam has come up with the guidelines. This is the office memorandum issued by the Department of Personnel, my lord, on 4th February 22. This is pursuant to Ajay Chaudhary's case. And in fact, my lord, there is one judgment of this honorable court also, where exactly the same situation has arisen, my lord. Here also, my lord, when the case was filed, it was said the charge sheet was given, but it was refused. But it was observed that there was no extension. And since there was no extension, it was satisfied.
Was paragraph 22 of the Ajay Chaudhary was taken?
My lord, paragraph 22 has to be understood in context of the facts. Facts in paragraph 6, where it says extension has been given. So if they would have given us extension and during the extension, the charge sheet was given, I would have understood.
The extension had.
The lordship will kindly see Ajay Chaudhary for a moment because it is very
What-
clear.
How many extensions are given is a different aspect of the
Well,
matter.
it has a relevant bearing, my lord, because if your lordship kindly first have the office memorandum 4th February, your lordship will find on the first paragraph it is mentioned because of Ajay Chaudhary. Then your lordship may kindly come to the second paragraph. It is therefore directed that all the senior-most secretaries of all the departments shall ensure that the memorandum of charge sheet is served on the delinquent officer before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer. If the memorandum of charge sheet is served within 3 months of suspension, a reasoned order must be passed for the extension of the suspension whenever necessary, wherever necessary. Then in the next paragraph, your lordship will, and the third paragraph, your lordship will see, senior most secretaries will be held responsible if cases of suspension in the respective departments are not dealt with and reviewed accordingly. However, for those certain categories of employees for whom disciplinary authorities are not the governor, the appointing authority shall be responsible. Last paragraph, all departments shall submit quarterly return to the personnel department. So these are to be rigorously followed. These are not just meant to be on papers. Now coming back to Ajay Chaudhary, my lord, paragraph 21. For the lordship, kindly allow me to just place it for a moment. I'm sure your lordship have read it at several times. We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period the memorandum of charge sheet is not served on the delinquent employee, if the memorandum of charge sheet is served, a reasoned order must be passed for the extension of the suspension. As in the case, the government is, well, so here, this is in 2 aspects, my lord. And before this comes the Deepak Mali's case, my lord, where also it was clearly held that there has to be an extension. If there is no extension, then that issuing of a charge sheet will not help. Now, this is Zakir Hussain of a coordinate bench of this High Court, my lord. Absolutely same facts, my lord. Because in this case, your lordship will see the suspension order is 24/12/2020. In March 23, they are issuing a charge sheet, and that also an intention. Anyway, my lord, coming back to Zakir Hussain.
But Deepak Mali is a case under the CCS rules.
Well, correct. That
And
rule
as
is
such,
there.
there is a provision out there in the
Yes, my lord.
10.6,
Amar,
which is not here.
well, lord,
As well as 10.7. As
we
well as
have
10.7.
the manual of department proceedings under which these notifications have been issued, my lord. Here it is categorically said the following principle and procedure with regard to suspension needs strict compliance. Number 1, suspension should be resorted to only in cases where a major punishment is likely to be imposed if the charges are proved. Number 2, charges and statement of allegations should be served within 3 months from the date of suspension, failing which the government servant concerned should be reinstated. But this is there in the notification, and these are,
But that's only a manual.
your lordship would recollect Justice Frankfurter's quote, which was quoted in that Ahluwalia case, my lord. Undoubtedly, it's an executive instruction. It has to be rigorously followed.
No, these are
Otherwise, it will be
circulars.
struck down.
No, Mr. Counsel, these are circulars to the effect which binds the authority, but it is not an enforceable right.
My lord,
There's a difference between that.
however, my lord, I was taking a
There are
lordship.
various Supreme Court judgments on circulars
anyway,
which
my
say
lord,
categorically
that
says that
aspect,
yes,
I
the
mean,
circulars are bound, binds the authorities, but it's not an enforceable right.
today I'm not carrying Ahluwalia's case. Otherwise, my lord, I would have placed that.
Hmm.
That was a case of promotion, I think
Hmm.
78, right? Google Maratha. But anyway, your lordship may kindly come to 2017 6 GLR 107.
Hmm.
Here at paragraph 9, neither the affidavit of respondents nor the submission of the learned standing counsel indicates that any such reasoned order had been passed by the respondent authority by which the charges of suspension of the petitioner has been extended. In such view of the matter, this court is of considered view that further continuation of the suspension in the absence of the memorandum of charge being served, and further, even if it is to be construed that memorandum of charges has been served in the absence of such a reasoned order being passed for continuance of the suspension order, the order dated so and so is no longer sustaining. So, my lord, here also there is no order of extension. Let my learned friend file an affidavit, my lord. Let him clear all this, because what they have given us is some correspondence. He's taking it up.
No, it's not correspondence, it's charge sheet. Charge memo.
And this is of 16th March. We filed our case on 15th March. After that, 13th March, After that, it seems this is dated 16th March, after we filed the writ petition with.
But
utmost
here also,
And here,
no, Mr. Goswami, here also,
Well, if that
the
is
coordinate
within-
bench does not take into account paragraph 22.
well, at 22, your lordship will have to appreciate with paragraph 6. Paragraph 6 in Ajay Chaudhary is clearly saying 4 extensions. I may just read that for your lordships. The learned additional Solicitor General has submitted that the original suspension was in contemplation of a departmental inquiry, which could not be commenced because of a directive of the Central Vigilance Commission prohibiting its commencement if the matter was under the investigation of CBI. The sanction for prosecution was granted on 1/8/2014. It was also submitted that the charge sheet was expected to be served on the appellant before 12/9/2014, that is, before the expiry of the 4th extension. However, we need not, then thereafter it is mentioned in 22 that now it has been served. So it is obvious, my lord, there has been extension. In another 2 paragraphs also I have seen it is mentioned that it has been continuously extended. Therefore, I am saying, my lord, otherwise, my lord, because of the law laid down in 21, these instructions
But
have
that's
been
it.
saved.
That's,
in-
no.
Unfortunately,
No,
the
but
person
Mr.
filing,
Counsel, does rule 6 envisage the requirement of an extension?
rule 6 of the Assam, no, my lord, not there, my lord.
Not
But from,
whereas,
from paragraph 21, my lord.
no. Here it is given, but if you, it is here, it is not required as per rule 6 for an extension.
No, my lord, I'm sorry, my lord, my lord, the way I'm understanding para 21 of Ajay Chaudhary, despite what has happened in that case, the Honorable Supreme Court has laid down the law in para 21. That there is no quarrel to that effect, my lord. Only thing that benefit of that law, the petitioner did not get.
No, why?
Because he was served the charge sheet within the extension.
No, it says then now. The
Well,
word used is
yes,
now
my
it
lord,
has been
that's-
given.
Word now cannot be read in isolation. It has to be read along with the other fact. In the preceding paragraph, it has been mentioned.
No, when the rule 6 does not contemplate an extension, where is the question of granting an extension which is otherwise necessary
My lord,
under the CCS rules?
my lord, for a moment, my lord, if your lordship kindly takes para 21 and then the guidelines which has now framed, which I have placed before your lordship, they have mandated there, my lord, that it has to be done. My lord, from 21, they have brought it, my lord, that you issue the charge sheet within 30 or 90 days. For some reason, if you cannot issue it, then extend it. And within the extension, you issue the charge sheet. There is no difficulty if one does that. But one cannot, in 2020, they have given me a suspension order. For 2 years, you don't.
But
do
why did
any-
you, why were you sleeping on this
Because the
one?
suspension was not served on me, my lord.
Huh?
I was not served with the suspension. I came before this court in another round of litigation, first round. In that, when they filed the affidavit, I came to know. And after filing that writ petition, they gave me subsistence allowance. And now, after filing this writ petition, on 16, they are showing a correspondence that the charge sheet has been issued. The facts are totally different, my lord. With utmost respect, let my learned friend file an affidavit. Let me get an opportunity, my lord, because this is at motion stage. And
But then also you got it in 2021.
21, my lord.
The suspension order which was there, you got it
No,
in
no, madam.
2021, yes? Because on the basis of which you got your subsistence allowance.
But 22/4/21, they have given, they have that order of 50% subscription that was given, but the petitioner at that time didn't realize, my lord. After he filed the writ petition on an affidavit was filed on 23 June 22. There it was given, my lord. The order was
When you
annexed.
got the you were given a subsistence allowance.
My lord, at that time, that order of giving the subsistence allowance was also not served on us.
No, but you got your subsistence allowance then.
Well, but with utmost respect, my lord, when we got it, at that time, we've already filed the writ petition, whereby we said you give, because my salary was not, they're not releasing my salary, my lord. So we asked for that. At that time, they suddenly released that, but at that time, we didn't realize. When they filed their affidavit, we've come to know this. And thereafter, we've withdrawn that with liberty to file fresh. That order also have annexed, my lord. That is how I'm before your lordship. Yes, yes. Later part of 22, we understood, my lord. And admittedly, they have filed they are now showing some document by which after I file my present writ petition, the charge sheet has been issued.
No, 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 prior to that, prior to that,
In reference,
prior to that.
in reference to the subject cited above, notice dated 2nd January 23, the departmental proceedings will be held on so and so in the office of so and so. So that means 2nd January 23. 23. After almost 2 years, with no extensions. This is
Where is the concept of extension? I don't understand.
But from para 21 and that.
Extension will only come when there is the question of, after serving the memorandum of charges.
But if for some reason charge sheet cannot be issued, then it has to be extended.
No, it is not required. That is not the mandate of Rule 6.
Look, I have seen that in another decision. Let me come back on this, my lord, because I may be wrong, my lord, subject to correction, but I understand para 21 in this manner. And that is how I see this the guideline office memorandum also being framed, my lord, where it says that either you give it within 90 days. If for reasons you cannot give it within 90 days, you extend it, and within this extension time, you give it.
Where is it?
It says, shall ensure that
Where is
the-
the question of extension? in
Uh,
this
uh,
office
It is
memorandum?
therefore directed that all senior most secretaries of all the departments shall ensure that memorandum of charge sheet is served on the employee before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served within 3 months of suspension, a reason order must be passed for the extension of the suspension whenever necessary. I understand what your lordship is saying, that only if a charge sheet is issued, then the extension.
Yes,
My lord.
that is
But
what is,
automatically, my lord, if
in fact, what they have done, they have
Very
just
well.
incorporated
very
paragraph
well, my lord,
21.
but if that is what is, my lord, then in a given case like mine, my lord, if for 2 years or 3 years, you keep me hanging on a suspension order and then you issue a charge sheet, the object of this is not met, my lord, because the object is that if you have material, then by extension, you show that these are the reasons for which I have to be put on suspension and there has been a delay. So ultimately, after 2 years, if you file a charge sheet and then give me an extension, that will not be used. In fact, in other decisions of this court and all, this is what has been clarified, that extension part. In fact, this decision of the coordinate bench here, precisely this is what the learned single judge have done. Paragraph 10.
But paragraph 10 has been taken into account without the paragraph 22 of Ajay Chaudhary.
In paragraph 5, Ajay Chaudhary has been,
But only
Next-
paragraph
next
21 has been taken.
yes. These are important questions, my lord. She may hear me on another date or let the pleadings get be
Well,
completed.
he let him
as
file an
your lordship
affidavit.
pleases.
How much time you take to file an affidavit?
Lordship, 2 weeks, your lordship.
But Mr. K. Goswami, the learned senior counsel, assisted by Mr. Ekta Til and Mr. T. Bora, the learned static counsel, appearing on behalf of the The learned counsel, Mr. T. Bora, had submitted that the petitioner have that the various attempts have been made to serve the memorandum of charges upon the petitioner, but the petitioner, for one reason or the other, have refused to accept. Taking into account the said stand, this court finds it appropriate that the said stand be brought on record by way of an affidavit, so that the petitioner is in a position to rebut to such allegations. Leaves the matter on 10th of April 2022.
Deeply obliged, my lord.
Otherwise, your lordship, this 27th, he may appear before the disciplinary proceeding. It is going to.
How can you appear without
Have not even
submitting a,
received.
yeah. You want to take a copy of the memorandum
No,
of?
let them serve, my lord, if they want to serve. They can't serve it to me.
Serve, he doesn't accept it.
It will only delay your, the inevitable.
Deeply
51.
Yes, please, your lordship.
Yes,
The petitioner was appointed assistant teacher in the year 1998 in Annexure 1,
Hmm.
base 23.
Yes.
Thereafter, case 23, 21/7/1998. Thereafter, at page 24, he was transferred from a.
You were
to a different
appointed as?
Assistant teacher. 80.
Hmm.
C. Bhupendra Nath, 80, at serial number 4. Serial number 4,
Bhupendra Nath.
yes.
The following incumbents are hereby provisionally confirmed in their service against the post retained prominently by. There you go.
Yes.
Then,
On next page is, I was transferred from Bhagwan High School to Bolodmari High School at page 24.
okay, then,
Then, my lord, then there is an FIR at page 25 lodged by my second wife on the account of bigamy and dowry at page, by the first wife at page 25.
then you are put under suspension.
Then I was put under suspension, mildly kindly note the date, 10/12/2004 at page 34. Page 34.
Then you have been.
Then there is a
exonerated.
judgment, my lord, which was passed, and I was convicted for a period of 1 year
So you are
at page
convicted.
35.
Ah.
Then it went before the appellate court. Appellate court upheld the order of the Laleh Session Court at page 72. Page
Then,
72. Then I moved before the High Court at page 78, and my sentence was suspended at page 78. 78, the matter is pending before this honorable court. Now, thereafter, at page 75/9, my lord, I was superannuated on 28/2/2022.
then,
No departmental proceeding, nothing has been initiated against me. Then I represented the matter before the authority at page 80.
then,
My lord, nothing has been done. My provisional pension has not been paid. So I have approached this honorable court for the provisional pension. Now there is no departmental proceeding. Once I have retired from service from 18th of May, on 28/2/2022, my lord. Departmental more than so many years, 1 year, my lord. I have not been paid, and the law under 21 of the Assam Service Pension Rule, 1969, my lord, it contemplates, my lord, if your lordship kindly see the Assam Service Pension Rule. My lord.
I remember nowadays it has become my CPC. Yes. You want to mention about B?
Yes. B, and it has. I have, to this context, there is a judgment of this coordinate phase as well as apex court also. Apex court, my lord, judgment 2014-7 SCC page 260 at paragraph 8. Once the appellant has
You've
retired
given a
from-
copy of it? Oh,
Yes.
No.
Yes.
You say that in respect to an incident of 4 years, you cannot initiate departmental proceeding. That is one. But what do you say about paragraph section 20, rule 20?
Page number 260.
Future good conduct is an implied condition of every lordship is looking to where 20.
So, rule 20.
20.
Because as of now, you have been, your sentence has only been suspended.
Correct,
nothing
correct. Your
more.
lordship is right, absolutely right. Now, what do you mean by guilty of grave misconduct? Whether misconduct is not about the misconduct of a government service, some public fund, public money. It's a moral turpitude maybe at the last stage. It's a bigamy. So whether.
They
your
could have
lordship-
very well initiated proceedings against you under the 65 Act rules. You can't marry twice. That is another aspect of the matter. That is, which they have not done. It is a different aspect of the matter. But the fact that as regards 20, the
Yes,
governor
I've
can
seen
still
that.
withhold.
I've seen that. But there is no reply. I have also repented a matter. At least they could have given a reply to me. There is no reply from the and I don't know
Yes,
where I
Mr.
stand.
Katunia, why haven't you paid?
In fact,
It is
I've
provisional
received instruction,
pension.
but regarding the payment, they have not said nothing, my lord.
What about the provisional pension? Because if you see the provisional pension and more particularly the office memorandum of 2002, it categorically mandates that if there is a criminal case or any departmental proceedings, you need not pay the discharge. But the provisional pension, isn't he entitled to?
Yes, my lord.
Then
Admittedly, my lord, there was no disciplinary proceeding till date, my lord. And-
disciplinary proceedings, now you can't have it.
Yes, my lord.
Because in view of B, 21 B2,
Yes, my lord.
you can't have it
4 years, my lord.
4 years. But as regards the other one, you can very well stop it. But otherwise, he is entitled to the provisional pension in view of Rule 22.
Yes, my lord.
So you want the provisional pension?
Yes, yes.
We dispose it of. You will be entitled to the provisional pension till the final adjudication of the other one. That's the only thing you can, as of now, unless that other aspect, because then they can take a call in terms of 20.
They can call the call. They can take a call.
That is the only relief you can get as of now,
Provisional pension.
provisional pension.
That's only I am just at present I am.
Only
But
that
for not interim, I am paying for interim.
interim, that is the final relief you can get as of now. Tomorrow, if you are exonerated, then you are entitled to the full pension. Liberty has to be given to you. That is the only way out. Otherwise, the matter has to be kept pending unnecessary.
It will not help me. That's the whole purpose.
I'll give you the liberty for moving the fresh petition if they don't give it after that.
My lord will kindly.
But
see one-
tomorrow, if you are still convicted, the sentence has been only stated. But if you are still convicted, they may take it into account in.
My lord will kindly see one. I thought that I should point out.
Yeah.
May not your lordship agree also. It's a coordinate bench judgment. How it was dealt in by this honorable court. 2022, my lord. SC online Guwahati 776. Paragraph 7 and paragraph my lord 8 we kindly see. Yeah, take it. This is your lordship one is not against a criminal case. Seven and eight.
Here, in this case, there is no question of any criminal
Yes,
proceedings.
that's right. That's right. Your lordship is right.
There are many matters on the motion day itself I have disposed of in respect to where
But that-
21B2 applies.
But that liberty should be given that I may move a. repetition of-
Absolutely, if something happens tomorrow, if you are not given under 21, if you are then also after being exonerated, you are not given the entire thing, then you are at liberty to come. But as of now, this court can't give you more than that. What do you say?
Yes, my lord.
That is the only
That
thing you
liberty is
can
open,
get,
sir.
Mr. Mitas. Heard Mr. D. Das, the learned senior counsel, assisted by Joanne and Mr. N.J. Katonia
For one,
appears on behalf of
1 and 2 is same, my lord.
respondent number 1, 2,
4,
4,
6, and 6.
6, 6. Mr. S.R. Boru appears on behalf of the respondent number 5. And Mr. A. Hassan appears for the respondent number 3.
Seven. Seven.
And where, finance is where?
7, my lord.
And Mr. P. Gogoi appears for the respondent number 7. The case of the petitioner herein was that the petitioner was confirmed into the government service by an order dated 21/7/1998 as an assistant teacher in Bagun High School, Gwalpara. Subsequent thereto, by an order dated 2/7/2001, the petitioner was transferred from Bagun High School to Baladmari High School, Gwalpara. One Dipti Rani Devi had lodged an FIR before the Gwalpara police station on 4/12/2004, alleging that the petitioner subjected her to cruelty, demanding 50,000 from her father and married another girl, Srimati Arati Nath from Gwalpara. The said FIR was registered as Gwalpara PS case number 300/2004 under section 498A/494/323/506 of the Indian Penal Code. Subsequently, the petitioner was arrested on 8/12/2004. Upon being arrested, the petitioner was put under suspension with effect from 10/12/2004 with immediate effect. During the period of suspension, the petitioner was paid the subsistence allowance as admissible under the FR and SR. Next. The court of the subdivision and judicial magistrate S. Gwalpara, by the judgment and order dated 18/12/2006, in GR case number 1047/2004, had convicted the petitioner under section 494 of the Indian Penal Code and sentenced him to undergo rigorous imprisonment for 1 year and to pay fine of rupees 3,000, and in default for simple imprisonment for 6 months. The petitioner, being aggrieved, preferred an appeal before the court of the Sessions Judge Gwalpara, which was registered and numbered as criminal appeal number 3/2007. The court of the Sessions Judge Gwalpara, upon hearing the parties to Gwalpara, by the judgment and order dated 11/1/2011, upheld the conviction passed by the subdivision and judicial magistrate S. Gwalpara. The petitioner thereupon preferred a revision petition before this court, which have been registered and numbered as criminal petition number, revision number 60/2011. In the said application, in the said revision petition, the petitioner also filed an application for suspension of the sentence passed by the learned session judge, which was registered and numbered as criminal MC case number 191/2011. This court, while upon hearing was pleased by an order dated 24/2011, was pleased to suspend the sentence passed by the learned session judge. The said criminal revision petition is, however, still pending before this court. In the meantime, the petitioner, upon a petitioner superannuated from the service on 28/2/2022. And thereupon, and the headmaster of Baladmari High School, Gwalpara, released the petitioner from general duty of regular service on the said date. Upon retirement, after the superannuation, the petitioner, the suspension order so passed against the petitioner had lost its effect. It may not be out of place to mention that as per the instructions so produced by Mr. N.J. Katonia, that the petitioner was never reinstated to the service upon after he was suspended by the order dated 10/12/2004. It is also the specific case of the which department? Secondary Education Department, that there has been no departmental proceedings initiated against the petition. The case of the petitioner herein, that the petitioner have rendered pensionable service tell me one thing, then also would he get it? Have you regularized this period? Without regularization, can he get?
Regarding the suspension period. That has-
Because otherwise from 98 to 2004, it is not in view of 108.
Yes, madam.
Then under such circular, wouldn't it require regularization of the period of suspension?
Yes, madam.
But otherwise, then also is he entitled to the provisional pension? Because otherwise 108 says he will only get the terminal death benefit. Yes, Mr. Gogoi, what do you say? Will be entitled to? Huh? But if it is, if he does not have the qualifying service in terms with 108, which is the minimum of 10 years, can the suspension period be taken into account? Unless it is regularized. So then without regularizing, because he was confirmed on 1998, he was suspended from 2004, which is only 6 years. Then what happens regarding the remaining period? Till the, and he was never reinstated, neither his suspension period was regularized, then what happens? Hmm? After the retirement, the suspension will automatically go. That from the date of suspension, with the date of retirement, it has to be regularized. So without regularizing, can it be done? So where the provisional pension is concerned, that is paid only as an interim relief, sort of an interim relief, till the final pension is paid. And that will be examined by the competent authority, that is the accountant general or the director of tax. He just will come.
Okay, so- Rule 22, my lord. Provisional, which would have been admissible on the basis of his qualifying service up to date of retirement.
So without regularization, can it be done?
Or if he was under suspension on the date of retirement, up to the date immediately preceding the date on which he was placed under suspension.
So then would he have the qualifying service? From 98 to 2004 in view of 108?
Yes, sir, only 6 years. Then.
Less than 10 years. 6 years,
10 years.
10 years, less than 10 years.
Hmm?
After service of less than 10 years.
108.
Otherwise, you'll be only entitled to terminal benefit.
The amount of pension will be regularized. No? Sorry, sir,
This part has to be looked into it.
And they can't regularize till the final decision of this.
But whether I am entitled to get the gratuity and all those things.
Gratuity can't happen because of the fact that you see the office memorandum of 2002. Have a look at it. If there's a criminal proceedings pending against you, you can't get it, isn't it?
Payment of provisional pension during the pendency of the resolution, but no gratuity or DCRG payable during that period. Case 15.
But what I understand from 20, my gratuity and other can be withheld only recover as regarding loss to the government. Suppose there is some misappropriation, some amount loss to the government, pecuniary loss to the government. This is
No,
what I
understood,
understand.
but what do you say about, you have the office memorandum? Is that the red book?
Red-
Get hold of the red book. You don't have it? Mr. Das, you are not into these pension matters, that is why. After rule 22, there is an office memorandum. You got it?
Yeah.
Office
Got it.
memorandum. In that case, my lord, provisional pension. Qualifying. The present case, my lord, the third memo has not been given to you. Separated from what the provision has been made by the. 22 otherwise will not come. No, 22 is for provisional pension. No, third, my lord, only my lord, those my lord employees against whom departmental proceeding is pending. Those are which have been retired. That case, my lord, 22 will come for provisional pension. So as of now, there is no departmental proceeding. Without third memo, my lord, it cannot. So that they have also categorically said, have not done any reinstated against him, neither discipline proceedings, not drawn any department proceeding against him by the disciplinary authority. So then 21 is okay. But the question is whether this particular period can be taken as the qualifying period. Let us see to rule 22 ever. Itu pun kumai dia 21 manut dia 26 tu.
Tapi apa ni? ইয়াতে এখন আছে নাকি?
Now, if we see Rule 21,
21.
here it says a judicial proceeding shall be deemed to be instituted in the criminal case, in the case of a criminal proceeding on the date on which the complaint or the report of the police officer on which the magistrate take cognizance is made. Now, what do you say about the last part of Rule 20? The above Rule 20 refers only to crime or misconduct occurring after the pensioner has retired from service and would not therefore cover a reduction of pension made for the purpose of retrieving loss caused to the government as a result of negligence or fraud on the part of the pensioner before he had retired. But see Rule 21, meaning thereby
Yes.
Rule 20 shall only apply when this has happened after the person has retired. Isn't it?
Yes, Manoj.
So it can't apply. So on account of criminal proceedings, you cannot, or any criminal proceedings which has happened, the government cannot. Under 20, you cannot.
Yes, Manoj.
So under 21, you have to do it. Reserves to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery for pension of the whole or part of any pecuniary loss caused to the government if in a departmental or judicial the pension is found guilty of grave misconduct or negligence during the period of its service, including service rendered under re-employment. So this is the power which is being done under 21. So the 21 have two aspects. One is the departmental and the other is the judicial. Now the judicial proceeding has been defined in B.
Yes, Manoj. B1.
B1.
In case of a criminal proceeding on the date on which the complaint or report of police officer on which the magistrate take cognizance is made. So under 22 it's a judicial proceeding, Manoj, where any departmental or judicial proceeding is instituted under Rule 21.
or where department is
The proceeding
continued
is-
under A of the proviso thereto against an officer who has retired on the 8th of 12th. Provisional pension not exceeding the maximum amount on the basis of his qualifying service up to the date of retirement. Or if he was under suspension on the date up to the date immediately preceding the date on which he was under suspension. So then how can he get it unless you regularize that?
Yes, ma'am.
But if 22(1) is came, where lordship has said that you have to some qualifying service, 22(1) can be seen.
That is what I'm looking
Yes,
into.
where any departmental or judicial proceeding is still under Rule 21, or where a department proceeding continued under Clause A, there to against any officer who retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing on date of retirement, date on which such proceeding. Final order upon a provisional pension not exceeding the maximum pension which should have been admissible on the basis of a qualifying service up to the date of his retirement.
Then
Or if he was under suspension on the date of retirement up to the date immediately preceding the date on which he was placed under suspension, but no gratitude or
so if you see in 1998, you were brought into the government service
correct.
and you were suspended in 2004.
4.
So your qualifying service as of now will be only 6 years. Then how can you get under 108? Then 108 says
In that 108.
after a service of less than 10 years, a gratuity not exceeding, except in
After
special
service-
cases or under the orders of the governor, up to a maximum 12 months on a one half months in for each completed 6 months period of the if the employment has been reduced during the last 6 months. So here you will be only entitled to gratuity if we take only these 6 years.
Well, this part I have to look into it. Is there any particular, any law on this particular, any judgment passed on the basis of the qualifying service? What do you mean by qualifying service?
Qualifying is 31,
I'm sorry.
rule 31. You have to meet those 3 conditions. We'll have it on some other day.
Yes, I will just look
Because
into
I
it.
think you have a difficulty in this unless this aspect of the matter is regularized. If they regularize it, but they won't regularize unless and until
Yes, my lord.
that is not.
Criminal case pending.
That is the biggest problem you have. But once you get over that, I think then they will have, they can't do it. So your best option is to finish up that 2011.
Well, you all also will
Yeah.
take any other date. We'll also look into it.
Yeah.
31, I have looked into it. There are only three conditions. For
And
qualifying
these
service.
3 conditions have been spelled out subsequently in such a manner, it becomes something more like what you call the Bhulbhuliya situation. Okay, I heard Mr. Dida say, I don't think that I heard the counsel appearing on behalf of the petitioner, senior counsel assisted by Mr. HK
Not-
and Mr. NJ Khatunia, the learned counsel appearing on behalf of the respondent secondary education department. Mr. S.R. Bolu appears for the Department of Pension. Mr. B. Gogo appears for the respondent number for Finance Department, and Mr. A. Hassan appears for the Accountant. Mr. N.J. Khatunia, the learned counsel appearing on behalf of the Secondary Education Department, submits that as per his instructions so received, the petitioner was put under suspension by the disciplinary authority on 10/12/2014. After suspension, the petitioner was neither reinstated nor there has been a departmental proceedings drawn against him
10/12/2004.
10/12/2004. Huh? The petitioner, however, retired from service on superannuation on 28/2/2022. An issue has cropped in while hearing the matter as to whether the petitioner in terms with Rule 22(1), read with Rule 21 and 108 of the Assam Rules, Assam Service Pension Rules 1969, would be entitled to the provisional pension, taking into account that the revision petition challenging the petitioner's conviction is still pending before this court. Leaves the matter after the behuvication. The instructions so received by Mr. NJ Khatonia is kept on record and marked with the letter X.
Item 14.
14. Yes.
I will serve the affidavit by the response number 1. And I have
In
to
this matter, I
finally
am
reply
supposed to
your-
file an affidavit, my lord.
The petitioner did not receive a single month's salary. Oh, you have filed an
Yes,
affidavit?
yes, my lord. Today morning I have filed, my lord.
Okay. Mr. NJ Khatonia, the learned counsel appearing on behalf of the Elementary Education Department submits that he has filed the affidavit today. Let the matter be listed.
The first week of April, Your Honor.
First week, no time. And immediately after the Bihu vacation on 28th of April 2023, along with the said applicant. The petitioner,
meantime, I
if so
will find my
advised,
reply, Your Honor.
be at liberty to file the reply.
15 to 18.
May it please the Lord. Also, in this matter, I pray for some time to file affidavit, Lordship. In
What
fact,
is the matter about?
This is the Lordship, the compassionate appointment, but the appointment itself is fake appointment, Lordship. On the
Oh.
last occasion, I received some instruction, Lordship.
Hmm.
In
Oh, those matter.
Lordship. In WPC number 2939 of 2020, I received instruction. However, the copy of the petition was not available with me.
Shall file an affidavit. No, Mr. Appearing for a fake appointment.
Lordship.
You have filed the affidavit.
No, Lordship.
Why?
Because the copy of the petition was not available with me in respect of 2939 of 2022, which I received the instruction, and I requested the learned counsel for the petition also to submit a copy, to which they given me a writ petition today. However, this is another writ petition. So a fresh writ petition has also been filed, 5255 of 2022. So I need to file affidavit in respect of both the writ petition. So I pray for 2 weeks time.
You give the copies?
Yes, Lordship, by tomorrow.
Mr. P.N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department submitted that although he has received the instructions in the matter, but he had not been able to file the affidavit in view of the fact that the writ petition, the copies of the writ petitions were not available. He further submitted he had made a request to the learned counsel for the petitioner who have agreed to give a copy, serve a copy of the writ petition in WPC number 2939/2020, WPC number 5434/2017.
In fact, in
And-
this resolution, we have already filed our affidavit.
Oh, you have filed.
5434/2017, we filed our affidavit.
And 2499,
2499 not required.
you have a
Lordship.
copy.
No, Lordship. Copy, I don't have any of the copy.
5434,
5255. I received.
5434, do you have a copy or not?
No, Lord.
Shall serve a copy of the writ petition that is 2939/2020, WPC number 5434/2017, WPC number 2499/2019 by tomorrow. List the matter again on 3rd of May 2022.
Like
The petitioner in the meantime, upon filing of the said affidavit, could be at No, the respondent in the elementary education department shall file their affidavit without fail by 26th of April 2023. The petitioner in the meantime, thereupon shall be at liberty to file the reply. If so advised.
21.
Yes, Mr. K. Gogoi. Oh, what is this matter about? You have filed affidavits. Very well. Who are you?
I'm representing Provident Fund, number 9. An affidavit is proposed to be filed by.
You have filed a, central government has filed a affidavit.
They were to file, my lord.
Oh, they have not filed it?
Direct. He over-
Affidavit in opposition filed by respondent number 1345. Additional affidavit in opposition filed on 5/4/2022. Affidavit in opposition filed by respondent number 9 on 10/2/2023. I think that is it.
No, man, that is
Nine-
from.
nine
Provident
is
Fund.
from my lord here.
Okay, so the central government has not filed the affidavit.
No, that was the first time.
Well, the central government seems to be not serious about the matter.
Well, that's it. They have filed affidavit. I have to indicate.
Central government has filed.
Yes, fine.
No, as per after the order dated 21/2023.
Yes, my lord, yeah. They ordered this court passed on 12th, 22/12/2022. Your city, you go, kindly go through, you will understand it better. There are-
Yes, I've seen it.
Uh,
Oh, I passed a long order,
Yes, my
a
lord.
very,
That-
very long order.
Yes, my
if
lord.
your
The
lordship takes
petition
up
is
your
not
lordship's
some.
order itself.
Huh?
If your lordship is your lordship's order, my lord, there's not the core issue was dealt with. And that there was a requirement of the central government to file this affidavit. Because
Okay,
this matter may have implications in so many other cases, my lord.
very
Because-
well. Oh, there was something to the effect, yes, I remember. In terms of the employees had stopped, oh, that one,
Yes, my lord.
where this. Yeah,
pension.
had
No, no,
stopped
I-
EPF pension in 443 cases. However, in the month of July the employees conveyed the decision that there is no provision for increase of pension under so and so. And therefore, again, it restarted the pension in respect of those persons when pension have already been stopped by it. Under such a way, it is resulted in double payment, double pension benefit to those absorbing pensioners of so and further. Now was thereupon requested to reconsider the decision taken in the month of July. However, the state order advised the airport authority of India to government pension by adjusting the amount of EPF pension. The state method thereupon was, it has been mentioned that the state issue has been sent to the department seeking clarification as to whether it would be permissible that an amount equal to government pension minus the EPF paid as government pension. This court has made a specific query upon Mr. Kirti Gogoi, the hearing. The Department of Pension and Pension Welfare have taken any decision in pursuant to the aforesaid matter by way of a clarification. And I submitted he would like to file an affidavit. This court would also make the no, take note of another of this memorandum. Passed by the Madras High Court, whereby the Madras High Court allows the petitioner therein to forego the EPF pension and opt for the family pension under the Tamil Nadu pension rule, and also directed the employees to not stop the payment of pension under so and so. Being made upon the learning council for the petitioner, submitted as per his instruction, the petitioner is willing to forego the amount provided the petitioner is granted the regular government pension PPO. The learning council is directed to file an affidavit on without pay. Until now, they have not filed affidavit.
No, my.
Yes, madam. Why you have not filed your affidavit? Don't give me the excuse that somebody is out there in some other court. Why haven't you filed the affidavit? That's not a reason not to file an affidavit. Then this court further directed. Considering the above, another opportunity is being. Have they filed the affidavit?
They have given, yes, they have filed the affidavit, they have got the.
Yes, give me a copy. What is their stand?
Nothing is done. Simply some, the earlier petitions are, the order passed through lordship on.
Yes, Mr. Gogoi. We have
11,
asked you to file an affidavit. You have filed the affidavit. Mr. Gogoi, you have filed an affidavit.
No, sir, I am not filed.
Why?
Lordship, I have received certain instruction from Ministry of Aviation, Lordship.
Very well.
Aviation says that, Lordship, it is pending before the Ministry of Labor, Lordship. If Lordship, permit, I can.
Both are under you
Lordship.
there?
Even Lordship, we have also communicated in the Labor Ministry also, and Deputy Solicitor General also communicated to the Labor Ministry, Lordship. We have await for instructions from them, Lordship.
When?
Otherwise, Lordship, Ministry of Aviation instructions I have, Lordship. They have given some certain communication, Lordship.
No, the question is very simple.
Lordship,
The matter has been placed before the Department of Pension,
Lordship,
seeking clarification as whether it would be permissible that an amount equal to government pension minus the EPF pension has been be paid as government pension.
Lordship.
That is the issue,
That is the issue,
which
Lordship.
is pending before the Department of Pension and Pension Welfare.
Lordship.
What are they doing?
Lordship, even Lordship, they have given one judgment of the Honorable Division Bench also, they have forwarded. Lordship. Honorable Cat of Delhi also, they have forwarded to me, Lordship.
What have they said?
Lordship.
Because in
They
Tamil Nadu, they have done it.
They have done it, even Lordship, the Cat judgment is also that, Lordship, it is direct to the department to take a decision, Lordship.
Huh? Same.
Same, Lordship, in the
But-
line of that
but
also, my Lord. may
Here,
dispose
if we give it to the department, asking them to file an affidavit, 3 months have gone by.
The Cat
Oh,
order,
this is
Lordship,
Cat.
Delhi Cat order, Lordship.
What has the cat said? In view of the limited prayer made by the learned council without going into the merit, the OA is disposed of at the administration with the direction the competent authority in consultation of so and so to take appropriate action. The passing a reason and speaking order and by following the principle with due grant the pension as paid for within a period of 2 months from the date of a certified copy of the order. This is not going to help this way out there.
Lordship,
So the petitioner would still come back here.
when Lordship, the communication from the Ministry of Aviation, Lordship, they have written to the Ministry of Labor, Lordship. They have not replied, Lordship. Even,
My lord,
even Lordship, I also try, even telling my part, Lordship, Deputy Solicitor General also written to the Labor Ministry, Lordship.
This is what I have written. Since we has agreed to this arrangement, considering which only the PO for government pension were to be paid by, but again request to reconsider however to the government pension. It also not complex to bring to your cabinet pension or completed one with you. In the state. So what to be done?
Lordship, be another chance, we will again communicate to the Ministry of Labor, Lordship. Otherwise, Lordship may,
These communications doesn't help.
Lordship may dispose of with a direction to the Ministry of Labor, Lordship.
No, this is also not helping.
Lordship.
Thing which is required to be done is they should also know about an order. being
Like in
passed.
Madras also, Lordship may dispose of, Lordship.
No, Madras is different. It is the Tamil Nadu rules which are there.
Lordship.
Now, can we apply the same thing here?
Perhaps yes, because if you lot would see what has happened, we were also getting two pensions, like EPF pension and the pension under the Madras Act. Here the case is not whether they will get the government pension or the EPF pension. So if not, the whole issue is, if earlier what they did not, the EPF authorities not stopped the EPF pension in some of the cases, my lord. And then on those cases, my lord, regular pensions were granted. But subsequently, my lord, they say that there is no provision under the rules to stop those pension. Therefore, they again reverse their decision. That's the house the situation is. So in that circular that I had placed in my additional affidavit, my lord, from there your lordship has not got this, my lord, that in Madras High Court in para 7 of page 33 of my additional affidavit, my lord, it has been mentioned. So my lord, this was also one of the suggestions that this could be done. So if in the present case, my lord, if EPF can be directed that you stopped your EPF pension, then my lord, and they will also forgo, my lord, they have already.
They have already
Yes,
stated they will
that
forgo.
direction would help them, my lord. But so far as the legality of the issues, my lord, that's
But would it be legal to do that?
Lordship may then direct the APF holder to stop, then he will get lost in the petitioner's case, that will lordship.
helps their cause.
That will help, that will solve their problem, lordship. If lordship directed the APF holder to stop the pension, lordship, we are bound to give him the regular pension, and then he will get the more pension also.
Perhaps the department wants that their direction should come from your lordship rather than they take their own decisions, my lord. That's the situation is, my lord.
Lordship can direct the APF authority to stop that particular pension, and then he will get the regular pension.
No, but then can this court direct in fine unless you show me
Lordship,
something
in the
by
light
which
of
I
the-
can stop it?
In the light of the Madras High Court judgment, Lordship may,
Huh?
Lordship may referring to the OM, my lord may referring to the OM issued by the Lordship.
Where is the
Ministry of
Madras
Civil
High Court judgment?
My lord, judgment is not there, reference is there. If your lordship take up my additional affidavit, my lord.
No, reference, no reference doesn't have. But where is the judgment?
Well, it has been quoted in that circular, my lord. Page 33 of my additional affidavit.
No, get hold of that Madras High Court judgment.
We tried
Mr.
online.
Sharma,
my
you
lord.
can get it? Oh, you are? Mr. PCR Medi, can you get it? The Madras High Court judgment?
No, I thought, my submission is, my government pension is to be paid. In the event, my EPF pension may be cancelled, because petition is so harshly facing financial hardship, she cannot live in LA. Today, actually, madam, may be, please be disposed of by giving me my government pension, along with the entire area already made as per his additional affidavit. With that, my case may be, please be disposed of. In the event, my EPF pension may be dropped. Common pension meaning with all areas. Areas have already been included in the additional affidavit.
Whose additional affidavit? Respondent number?
F,
1, 3, 4 and 5, my lord.
Which affidavit additional 5th April?
Yes, my lord.
additional affidavit at annexure 5, my lord. Page
No,
19,
annexure 5, annexure F.
annexure 5 also there.
My lord, kindly take page 32 for a moment, my lord.
Of your additional affidavit,
Yes, my lord.
office memorandum.
Yes, my lord.
That is the one which is,
No, we moment
yes,
separate
yes.
matter.
And para 7, my lord.
that is what he is, just showed it to me.
And that your
Moment
lordship has
separate
incorporated
matter,
in the
madam.
order also, my lord.
Annexure F,
Annexure?
page 19, additional affidavit. At the page, his entire area has already been put there. Of the EPF pension also government pension area. With that area pension, my government pension may.
What is the area? 7,96,000.
No, 7, that is EPF, my lord. Government pension is
But that is one
26
some late
26 lakhs,
Manoranjan Roy. Who are you?
Wife of,
Late Manoranjan Roy. So you are entitled to this 7,96,000.
Not that, my lord. That is my government pension is 26 lakhs, 76,485
Pension areas.
pension area.
You are entitled to this
Yes,
that have not been paid.
not that. They have given it, they have kept it ready. They have kept it, but not yet, not yet. Consent is given, the area is also.
We'll do one thing. We'll dispose it of on 28th. Okay?
28.
8. You get whatever instructions and get hold of this Madras High Court judgment. You have the case number. You just find it out there.
Yes, Lordship, it is there. Full time.
Ah, get hold of the Madras
It's
High
not
Court. judgment.
available online, my lord.
Huh?
I tried, my lord. It's not available online.
No, try it out there. I think in the Madras High Court website you'll get
No,
it.
it's not available. I checked it.
Then you
Yes,
take it
ma'am.
up with the Manupatra people and they can give it to you. When I used to be a lawyer, I used to get these orders in this manner. It is not available. I hope I don't have to do such things there after becoming a judge. This is the matter on 28/3/2023, on which date an attempt shall be made to dispose of the matter.
Lordship,
In the meantime, Mr. K. Gogoi, the learned council, central government council shall try to obtain the instruction as thought for by the orders passed in the writ petition.
Lordship.
22.
Yes, Mr. Bora.
Later pertaining to the petitioner given retirement before supervisor. At the early days, he was appointed at the time of minor. And the
Matter
allegation,
pertains to superannuation of the petitioner for service of
allegation
FCI.
that petitioner has been continued 42 years
Rather,
service.
contends that as per the birth certificate enclosed in the registry, his date of birth is 1925. But if that he ought to have retired in Yes, anything has happened, Mr. Roy?
No, but so far as the pensionary, on the last occasion, there was a direction to consider pensionary. This is under process, pensionary benefits. This under process, this can be given.
I think he is more aggrieved by the fact that you have superannuated him, isn't it?
Yes, that's right. Yes.
As per you, you should retire on 2026.
26. 28 February.
So the moment he accepts the pensionary
That's
benefit, the matter
I was also indicating my learned friend that if he accepts that, so Lordship will have to hear the whole matter because there were divergence of views in the Supreme Court. Lordship will have to accept either of the two.
And when has this aspect been brought into the notice of you that he is supposed to retire in 2026 and not in 2020? In the service book, was it recorded? What was his date of birth was recorded?
My lord, yes, because my lord, at the initial stage, he was asked at the initial stage of appointment. At the time of appointment, he was asked to produce the age proof certificate. He did not do so. His services are regularized. At the time of regularization, my lord, he submitted a certificate after 7 years. He said he entered into service in 1978. Certificate has been given of 1985, so passing in 1985. There, his age shows that the date of entry will be 12 years, minor. So, so my lord, he was taking age of 60 retirement. He will be serving 42 years. Therefore, after 42 years, my lord, he was.
So 12 years was his age.
Was
When
his age. According to the certificate, he has submitted later, much later. So this initial stage he was asked, but he did not. That's the problem. Petition number 3, how I will get the service? Petition number 3. At the early stage, the petitioner family is very poor. And for such
Whatever may be poor or rich,
Yes.
one thing is happened.
Yes.
You can't be given the service as with the 12 years.
Yes.
Otherwise, FCI tomorrow would have a lot of problems of employing teenage persons. Not teenage, even.
My
Minor.
service also illegal and he also abused me.
Huh?
Respondent also abused me. My service also at that time of minority.
You want to go back to that?
Yes. That by considering that as a boy service, by exempting the early days, My service.
Mr. Bora, the problem which will arise is if your appointment is on the basis of a fake document, what is the consequences? You know that.
My document is not.
No, your date of birth certificate, if it is fake,
No, they have not challenged till today. They have not challenged.
not necessary. How can there be a 12 years you can be appointed?
No, they have
As a
abused
cook.
me. That's why I'm challenging it.
Yes.
Because at that time of minor, they
Answer.
cannot appoint me until and unless 18 years. Now they have reckoned 42 years.
Mr. Bora, today is at a late day. Well, it is too late in a day today. Otherwise, this is a case for, it may, I tell you, this may affect against you. They may take up the issue that the appointment which have been given or the document on which it has been done was a fake document.
But they have not challenged.
And you know, recent Supreme Court judgments to the effect that a document, if a person is appointed on the basis of a fake document, then the matter ends for all.
My document is matter. That is correct. My document has not been challenged. Till today they have.
Not necessary,
My lord,
not necessary. But what will be the consequence with you?
they have asked me by letter that you produce the original documents as proof. Accordingly, I have submitted original copy. That was accepted.
Understood, but how can you be 12 years when you have been given an employment?
That is not. That is not. That is true.
How can a 12-year-old boy be employed as a cook?
No, there's a canteen boy. That was a canteen boy as a lump sum pay. They have engaged.
What was the minimum age of minimum age?
18 years.
Then
That is correct.
if it is 18 years, then how can you be employed at 12 years?
By considering that as a boy service at the earlier.
Is it permissible?
From the date of
No, no,
registration, my
Mr.
service can be reckoned.
Mr. Bora, is it permissible to employ somebody who is 12 years of age when the minimum age required is 18 years?
Yes.
Is it permissible?
Until and unless 18 years, no.
Matter ends there. Your appointment, the threshold of the appointment becomes wrong. And you know, there are many judgments to that effect.
For the sake of academic qualification, my lord, suppose I am a minor, they well know how they abuse me. That is, they have also made.
For that, take up a steps before the where you want to do.
That's why I'm
In the criminal
saying that
courts.
my
Take it
service will
up
be
with
continued till-
take it up with those authorities. File criminal cases against them. All this while. But how can you now say that this is it?
My lord,
You may
maybe
learn
we
in
can have
trouble.
another day, but I am suffering from serious financial constraint. Earlier order that honorable reasonable court directed to pay me some certain benefit, service benefit, but that has not been released till today. Last 3 years I am suffering along with my family.
Everything will be given, provided you accept your appointment properly.
No, that has been.
They may
challenged by-
tomorrow say that whatever you are, they may go for recovery also. Illegally appointed. See, sitting out here in the bench, I see there are persons who have been only 1 month or 2 months, they have not been released the pension.
My lord, there is Supreme Court judgment, my learned friend has referred, and last 3 years they have elapsed by referring this. Larger branch has said yes. By considering the age factor, whatever maybe department has done, he service may be Gopal Prasad in the
Service may be,
Gopal Prasad. He may be continued till the date of retirement.
how can it be?
I submit return with another
This
day.
is the matter after Bihu vacation.
No, my lord, before that. Before that,
Before,
before Bihu vacation.
not possible. You come on a Saturday, Sunday.
But auntie, the pension which has been earlier ordered passed by this honorable court, that may be released.
In the meantime,
23.
the respondent, as per you, he has retired,
Lordship,
may take effective steps for release of the pension.
Lordship.
It is further made clear that the acceptance of the pension shall not prejudice by the petitioner shall not prejudice the rights of the petitioner in the writ petition. Yes, Mr. Das.
Here the petitioner is praying for compassionate family pension. In terms of the,
14.7.
yes, 14.7.
Yes, Mr. Nayak. Any information?
Yes, Lordship, I have received
One is-
instruction, Lordship, in fact, his service of the husband, Lordship, was regularized in the month of July, and he died in the month of December, Lord. So his regular period is only 6 months, 5 months, like that. Lord. And for a compassionate family pension, 1 year service is regular, necessary.
Is it? Where is it? You have the scheme?
Yes,
That
Lord,
in
I have
the- it is there in
annexed
the notification, Lord.
page,
Where?
page 55.
57. Lord.
The relevant portion, my lord, will find page 55.
Where is it mentioned that it requires 1 year of regular
However,
service?
page 55, my lord.
A
para five
minimum
point-
of 1 year continuous. Government servant must complete minimum of 1 year of continuous service without break before death while in service. Then, where's the regular service?
But he was regularized, he was initially appointed in the year 2011 in pursuance to an advertisement, in pursuance to a due selection process against the sanctioned post. But what the BTC authority did, my lord, instead of giving him regular appointment, they kept him under fixed pay. Since the year 2011, that joining report, your lordship will find
Subsequently, what has happened? You have been confirmed?
thereafter, yes, my lord.
Where?
Thereafter, in the year 2018, he has been, my lord, posted in the pay scale.
Oh,
That
pay
is
scale
page
only.
48.
Pay scale is nothing to do.
He has,
You are a government servant for all
Yes.
times to come.
Yes,
Then,
my
Mr. Nayak, here it doesn't say
File my
anything.
instruction, Lordship. I have already received instruction, Lord. Let me file that.
We'll take it up next week.
Lordship will give me some. 2 weeks
No,
time.
no, 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 no. This matter has been
this
pending
lady
since
is
long.
facing some problem.
This
She's
matter
a
has
widow,
been
my lord.
pending since the 2021. Why haven't you
sir.
filed your affidavit in the meantime? No, no.
No, in the meantime, Lordship, I'll file. Lordship will take up this matter after 2 weeks.
Yes, we'll take it up next week. This is not because the person concerned heard Mr. H.K. Das, the learned counsel appearing on behalf of the petitioner, and Mr. P. Nayak, the learned counsel appeared on behalf of the petitioner. It appears on record that on 9/12/2022, Mr. Nayak had submitted that he had already received the instructions and he would like to file the affidavit in the matter. Good stop. Who is appearing for respond number 5?
They have filed an affidavit, my lord. Respondent number 5 is,
Mr. Naik, are you appearing for respond number 5?
No, Lord. I am appearing for 3, 4, 6, and 7, Lord.
what are you?
It appears that no affidavit has been filed till date. Taking into account the same, let this matter be listed. A final opportunity is given to file the affidavit to the PTC by 27th of March 2023. Let the matter be taken up on 29th March 2023 at 2 p.m.
Deeply.
24.
Matter relates to recovery of overdrawn amount, very small amount, my lord. 69,000.
I think Lordship, Guwahati High Court has to be made party, Lordship.
Whom?
Guwahati High Court, Lordship, because MSCT from the instruction has come from the MSCT, Lordship. Nalbari. Guwahati High
Yes,
Court
my lord.
has to
Notice
be
was
made a
served, my
party,
lord,
Lordship.
upon the MACT, Nalbari, my lord.
What are you asking for?
My lord, first, my lord, overdrawn amount as dear, my lord. Set aside the order, my lord. Then,
And
then,
then
my lord, second prayer is, my lord, consideration for MACP, my lord. Modified
directed the
Ratio.
treasury officer to recover rupees so and so from the petitioner year of the future. And also to direct the performance of the petition of that. You got a stay? You received the stay.
stable.
You make the Guwahati High Court a party if you want. Is it required?
Because
As per you, Mr. Sharma, is it required?
I'll do it, man. My lord, I know,
What is
notice,
this?
notice was already sent to Motor Accident Claims Tribunal, Nalbari, my lord. Trustee service. Trustee service. I'm under-
Who is the authority who has done all these things? Who
My
is,
lord,
who is going to give you
My
the
lord, Motor
MSCP?
Accident Claims Tribunal, Nalbari.
Do they do it under the direction of the High Court?
Yes,
Then why haven't you make him a part?
yes, ma'am. I'll do it, ma'am.
Mr. J. Sharma, heard Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner. And Mr.
I'm for
S. S.
respondent number,
Roy appears for respond number.
lordship, one, lordship.
To you,
KK Medhi appearing for respondent number 2. KP.
and the KK Medhi appears for respond number 2. Who appears for the Motor Accidents Claims Tribunal?
No, no.
Okay. And Mr. P. Nayak appears for the respond number 4. The learned counsel for the petitioner has submitted that the relief sought for in the instant writ petition cannot be granted. That an effect for passing an effective writ in the instant proceedings. It is required that the Guwahati High Court, represented by the Registrar General, is required to be made arrayed as a party to the instant proceedings. Taking into account the same, this court, in the interest of justice, arrays the Guwahati High Court, represented by the Registrar General of the Guwahati High Court, as the Guwahati, as the respondent number 5 in the instant proceedings. Mr. H.K. Nath. H.K. Das, who is present in the court, accepts notice on behalf of the newly impleaded respondent number 5. The registry is directed to make necessary correction in the cause title of the writ petition. The petitioner is directed to serve an extra copy of the writ petition upon Mr. H.K. Das, the learned standing counsel for the Guwahati High Court, by tomorrow.
Obliged.
List the matter after 4 weeks.
Obliged.
26.
Yes, Mr. M. Khan.
Kindly peruse the last order of this honorable court.
Contempt, initiated a contempt, oh my. Oh, that matter. Who is appearing for the, which department, the secondary part?
Lordship, sanction has been given, your lordship.
Very well. See?
Already amount has been sanctioned, but yet to be disbursed to the petitioner account.
You'll get it. Why will they not do it? 1,32,983. Only for payment regarding 6% interest per month with effect from March on 1,44,000 only in respect of the Government of Department of Food Education have already sanctioned. There is a direction to the Treasury Officer.
Budget allotment is also given, your lordship.
Huh?
Next page, your lordship. Budget allotment to DDO, your lordship.
Directed budget allotment has also been given. Heard Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, and Ms. D. Musari appearing on behalf of the Secondary Education Department. This court, by an order dated 2023, have in detail narrated the issue involved in the instant proceeding. On the said date, the learned counsel appearing on behalf of the Secondary Education Department sought for an accommodation of 30 days with a clear undertaking that within the said period, the petitioner would be released her remaining entitlement as per the order dated 2/11/2018. Ms. D. Musari, the learned counsel appearing on behalf of the Secondary Education Department, had submitted that the governor of Assam had sanctioned an amount of rupees 1,32,983 for payment to the petitioner, which is the 6% of the interest per annum with effect from March 2007 on rupees 1,44,074. Good stuff. Madam, what are these conditions?
Lordship,
What are these conditions? These have no relevance out there.
Lordship,
This is to be made in terms with the directions. Where are these conditions out? Although the said communication dated 16/3/2023 shows that there has been a sanction, but the petitioner is yet to receive the said amount as have been submitted by Mr. Khan, M. Khan. Considering the above, let the matter be again listed on 31st of March 2023, on which date the learned counsel for the petitioner as well as Ms. D. Musahari, the learned counsel, is the Treasury Department a party? Is a party?
Lordship, the Accountant General is a party.
No, Accountant General is, on which date Mr. M. Khan, the learned counsel for the petitioner, Ms. D. Musahari, the learned counsel for the Accountant General, for the Secondary Education Department. And madam, you are, your name?
Yes, Parikh.
S.
Parikh.
Parikh. Appearing for the Accountant General AE, shall apprise this court as to whether the said amount of rupees 1,32,983 has been disbursed to the petitioner. Good stuff. A copy of the communication is kept on record and marked with the letter X. And then see to it, the payment goes. Because these conditions, I would have otherwise disposed of. What, but why these conditions have been unnecessarily put out?
27.
Obliged.
Man,
My lord, matter pertains to pensionary benefit. my lord.
Then,
And as per last order, the respondent number is supposed to file his affidavit in opposition.
yes, why haven't you filed affidavit?
Lordship, affidavit is not filed, but Lordship, now the respondents are processing the Lordship for regularizing the service of the mother of the petitioner, Lordship. In fact, there is an order in 1993, Lordship, Park General Court, to regularize the service of the mother of the petitioner. Though the mother of the petitioner was engaged in the irrigation department, Lordship, her service was not regularized at the time, Lordship. Now, this is the case, Lordship. Now the petitioner, the respondents are initiating process for regularizing service of the petitioner, Lordship. Lordship,
How much? How much time you require?
Lordship, may fix the matter after Bihu, Lordship. I will.
Mr. N. Upadhyay, the learned counsel appearing on behalf of the irrigation department, submits that the services of the mother of the petitioner, mother of the
Mother of the petitioner.
Lordship.
Is right.
is in the process of being regularized. And as such, some time would be required to apprise this court as regards the present, as regards the steps taken for the pensionary benefits as well as the family pension of the petitioner. Considering the above, let the matter be listed on 10th of May 2023. Mr. N. Upadhyay shall apprise this court on the next day as regards the status of the process of regularization of the petitioner, as well, mother of the services of the mother of the petitioner, as well as also as to whether any proposal has been sent to
The finance department for their approval, Lordship.
Lordship, may I pass an order issued by chief engineer to the commissioner and secretary to the irrigation department.
This is a
Pursuant to order
letter,
dated first on 29/4. Regulation process have already been sent to the commissioner secretary. Lordship.
understood, but it has not been completed. That is what he is
Yes.
saying. Huh?
Lordship, all right.
28.
The accountant general, huh? Yes. Oh, none appears. You got some instruction?
Lots of that instruction is there.
What is the petitioner asking here?
Petitioner is asking for statement of revision
To
of pay.
adopt the fitment table 1.8 to disburse the salary of all the trained graduates were appointed as stipendary in a month. All of them are included to get the pay of trained. May be mentioned that the teachers who are undergraduate pay or graduate their pay before the pay was revised as per Now, what is it? Means you have allowed it.
Lordship, these petitioners are trained graduate teachers, Lordship.
They are trained
Lordship.
graduate teachers.
So yeah, all of them are eligible to get the pay of trained graduate teachers of LP school. It will mention that the LP school teachers who were undergraduate trained or graduate untrained, their pay was revised on 1/4/2016 as per amendment fitment table 1.8. As their pre-revised grade pay was 2,500 as per ROP 2006, and the teachers trained graduate before 1/4/2016, their pay was revised on 1/4/2016 as per fitment table 1.9. As per the pre-revised grade pay was, as their pre-revised grade pay was 2,700 as per ROP 2006. Accordingly, they were allowed to draw grade pay as per ROP 2017.
Now, what is his prayer?
Prayer,
Prayer is should not be issued directing the respondents, more particularly the respondent number 3, 4, and 5 to adopt the fitment table 1.8 to disburse the salary for all trained graduate LP school teachers instead of adopting fitment table 1.8 and 1.9. We put it on, yeah, none appears on behalf of the petitioner on call. Mr. P.N. Sharma.
Perhaps the Department of Finance is also
Huh?
necessary party. Department of Finance is perhaps the necessary party. here.
No, it's okay.
No.
Mr. P.N. Sharma, the learned counsel appearing on behalf of the elementary or secondary
Elementary.
Elementary Education Department submit that he has received instruction which have been placed before this court. The same is kept on record and marked with the letter X. Taking into account that the petitioner is not represented, let the matter be listed after the behudication.
Even the Department of Finance has also not been made party.
Understood, but petitioner is not there. It doesn't look nice.
30.
Yes,
The petitioner before Latif has not received a regular pension, though he has been retired on.
Mr. Borua, have you got your instructions in this matter?
Lordship, they have said they have not received the proposal, Lordship.
Mr. Katanier, where is he? They have not received the proposal.
Yes, Lordship.
Mr. Katania says that they have on behalf of inspector has submitted that on 1/3/1/2000 pension papers of the picture was forwarded to the director of pension. Where is Mr. Katania? Who is appearing for this department?
Secondary education.
Huh?
Lordship, he had some difficulty, so he had to leave your lordship.
Very well. You are there for the secondary
Lordship,
education department.
Lordship.
Why it has been mentioned wrongly that you have sent when they have not, or is it in the process for the last 3 months, 2 months?
Lordship, because
Sending it by a bullock cart, then also it will reach. 2 months is too much. You have sent it?
Lordship, as for last instruction, Lordship, it was sent to the.
And they have not received it. Either of you is right. Where is the instruction that you have sent it?
As annexure, as letter X, your lordship,
Hmm?
letter X.
Yes. Yes, this is the P1/2023. Forward herewith the pension papers of Nikhil Chandra Dev Sharma. The details of the government use are nil. This has been forwarded.
Lordship.
Then why haven't you received it? There's some number. ISDLP Peter Gata 2961.
Lordship, I will collect this from the standing council. I will ask them again, Lordship.
It is already there. Mr. S.R. Borua, the learned counsel appearing on behalf of the Director of Pensions on instruction dated 14/3/2023 has submitted that the Director of Pension is yet to receive the pension proposal of the petitioner. It however surprises this court that on 3/1/2023, the inspector of school, Gwalpara Division, Gwalpara
District Circle.
have file number IS/GLP/Kritagata/2961 have sent the proposal of the petitioner on here. Then proposal. However, in that view of the matter, both the learned counsel for the secondary education department as well as the director of pension shall take appropriate step with their departments and apprise the court on the next day as regards the status of the pension proposal of the petitioner. List the matter again on 29th of March 2023. The copy of the instructions was submitted by Mr. S.R. Bolwa is kept on record and marked with the letter Y. Gutas.
Item 32 to 34.
Mr. Sharma, you have got anything?
Lordship, in respect of WPC 6562, Lordship, I need to file affidavit, Lordship. That instruction is awaited, item number 32.
Okay.
However,
And
item number 32, 6562 of 2022. Although in respect of WPC.
other matters are?
Other matter, the similar matter, Lordship, in 1015, we have already filed our affidavit.
Okay, in 6562, you want to file affidavit?
Lordship.
Mr. P. N. Sharma, the learned counsel appearing on behalf of which department? Secondary or
Elementary, Lordship.
Elementary Education Department. 6 for an accommodation of 2 weeks for
Lordship.
filing the affidavit. Taking into account the same, let the matter be listed again on 10th of April 2022. In the meantime, the said affidavit be filed.
35.
Worship, the petitioner is a retired government employee, my lord. He retired as assistant director on 2017. Lordship, as on date, his leave salary and leave encashment has not been paid to him. For
You have
certain
got it.
period. I have not received, Lordship. They have filed an affidavit, no outstanding. dues.
Affidavit has been filed, Lordship, stated that there is drawn his monthly salary as a superintendent with effect from 1/3/92/28 to 11, including the leave period of 26/6/19 to 13/7/19, 9, Lordship. Yes, got the amount,
Lordship,
Lordship.
against the affidavit of opposition, I filed my reply. Lordship, on 27 to 2023. Lordship, I have annexed on communication. Lordship, at page 58 of my affidavit in reply, my lord. Relying on a communication issued from the senior accounts officer to Undersecretary Government of Assam Food and Civil Supplies. It's of 13/1/2023. And according to that communication, I have got 254 days to my credit, your lordship, on leave. Last slide.
So you had 254 days.
That-
And have you paid that 254?
Lordship, as per our affidavit in opposition, Lordship, stated that
How much you have paid? This is only for leave encashment?
Yes, my lord, leave encashment and leave salary.
Where is that? 254 days?
Last line of my affidavit in reply, this is the latest communication after the affidavit opposition filed by them. my lord.
Understood. Have you received that,
No.
paid the 254 days?
Lordship.
His affidavit is of 2022, my lord. This communication of 2023.
Affidavit has been filed, Lordship, is 6/12. 6/12, 5th December.
You take your instructions, Mr. Chakraborty. In pursuance to this affidavit in reply. Mr. H. Chakraborty, the learned counsel appearing on behalf of which department?
1, 2, 4, 5, 7, 8, and 9.
Department.
Lordship.
Which department?
Department is Food and Civil Supply, Lordship.
Food and Civil Supplies Department submits that he will take instructions in response to the reply filed by the petitioner to the affidavit in opposition filed by the respondent number 4, and more particularly to the contents as mentioned in paragraph number 3, 4, and 5 to the said affidavit in reply. This is the matter again on 10th of April 2023.
36.
May I take it?
Yes, which department? Secondary. Madam, Why no affidavit filed?
Lordship, your PTC is required, your lordship, because
Who is required?
PTC, the penny council of the PTC.
My lord, finally 2 weeks time may be given for filing affidavit.
Relating to what, madam?
Lordship, a matter relating to recovery of excess payment of the PTC.
They have taken the money from you.
No,
You have not paid. Very well. Now what do you want to do?
My lord, kindly 2 weeks time may be given for filing affidavit.
And have you got your pension?
No.
Oh, that is stalled because of that. And when did you retire?
let's see, 30/11/2020.
21. 16/11.
30/11.
30/11. Okay. Ms. Musari, are you filing any affidavit?
Lordship, here we have written a letter to the IS Inspector of Schools, Tirang, your lordship. If they give us a parawise comment, then we'll file.
Otherwise, you are not interested because last time you said that 2 weeks time is granted to the secondary editor to file the affidavit in the instant matter. You are not interested.
Lordship will file, your lordship. We'll file, your lordship.
And Mr. the PTC,
PTC Inspector of Schools.
you are appearing.
Yes,
You are
I am
going,
appearing.
you want to file an affidavit.
Yes, ma'am. 2 weeks time may be.
Okay. Heard, Miss?
You have a
You Hazarika, the learned counsel appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the Secondary Education Department. And Mr. S.R. Raba appears on behalf of the PTC.
Yes, my lord. 6, 7, 8. I've got 25.
Mr. S.R. Burua appears for
Is that-
the Director of Pension. And Mr. A. Solia appears for the Treasury Department, Treasury Officer. The petitioner herein had retired on 16/11/2000, 30/11/2011, 23/21. However, the petitioners have not received the regular pension, but you have got the family provisional you have got? Nothing. Have not received any pension, either the provisional or the regular. The learned counsel appearing on behalf of the Secondary Education Department as well as the PTC seeks for a further accommodation of 2 weeks. Let the matter be listed again on 10th of April, 11th of April 2023. The said respondent shall file the affidavit without fail on or before 10th of April 2023. Taking into account that the petitioner have not received either the provisional or the regular pension since 30/11/2021. This court makes it clear that the court shall take up the matter for disposal on the next day on the basis of the materials available on report.
37.
File your affidavit and whatever.
Lordship, may it please us, the petitioner is a retired government employee. My lord, he was placed under suspension on 14/9/17. Subsequently, he was reinstated, your lordship. And your lordship, he retired as joint secretary on 30/6/2018. During the period of suspension, he has not been paid his subsistence allowances, my lord. And other benefits also been withheld as on it, although he is receiving provisional pension. On the last occasion, they have made a submission, my lord, subsistence allowance have been paid to them, although it's not recorded in the order, reflected in the order, my lord. But as on day, nothing has been paid to him, your lordship.
You have not got your subsistence
No,
allowance?
nothing, your lordship,
And what happened? What happened to your departmental proceedings?
nothing.
You have
Although
retired?
I have retired, nothing, although Shokus notice was issued, nothing has been done. My criminal case, it was, discharge was, order of discharge was passed, my lord, in my favor. The accusation.
Not as per instruction, lordship, they have stated that gratuity fund in respect of Vinod Kumar Deka SCS has not been released due to pending of departmental proceeding against him, lordship. By departmental order dated 21/6/11, Lordship, under section 22 of Assam Service Pension Rules, Lordship.
22.
It's for the instruction, Lordship. The instruction. Section 22 of Assam Service Pension Rules.
Yes, Accountant General, why haven't you released? You are getting the provisional pension.
Yes, but lordship subsistence allowance and other benefits, my lord, and I'm entitled to it. They have not done anything, your lordship, as regard.
You have not paid the subsistence allowance.
Nothing, your lordship. I have a specific instruction. from
And
my
what
side.
about the departmental proceedings? She
Nothing.
doesn't know head or tail about it.
Nothing, your lordship, nothing has been done. Although in the order revocation, the suspension order, it has been reflected without prejudice to the department proceeding.
There's a
Nothing has been-
sanction of also the payment of subsistence allowance to so and so for initial period of 3 months at a rate of 50% and then so and so. Why no payment has been made? In 2018 also there is a sanction. Then
Subsistence allowance, Lordship, has been sanctioned, Lordship. That's what I instruct.
and then Madam, here it is mentioned that the subsistence allowance has been sanctioned.
Lordship, as on date not paid to me, I have taken specific instruction from my client. And on the last occasion, when the matter came up, they were directed to take specific instruction from the department, my lord. Lordship, we
what?
only see the last order.
Last order is at the request of the learned counsel for the petitioner, let the
81
matter be listed after 4 weeks.
Not 23. Last, second last paragraph. In the meantime, learned additional senior
That is
government
one
advocate should take
before.
appropriate and proper instruction.
Okay, do one thing, heard Miss Bornali Bhuya, the senior counsel assisted by and Mr. A. Chakraborty appears on behalf of
4, 3, and 6.
Huh?
4, 3, and 6 respondent number.
3, 4 and
2, Lordship.
huh? 3, 4 and 6.
2 also, Lordship.
2, 3, 4
4
and
and
6.
6.
Mr. A. Hassan appears on behalf of the respondent number 5. And Mr. A. Pukon appears on behalf of the respondent number 1. The learned counsel appearing on behalf of the respondent numbers 2, 3, 4, and 6 had submitted that the Provident Fund oblique GPF in respect to the petitioner are not withheld by the government. And the Accountant General AE have been already communicated by the communication dated 29/3/2019 for final payment of the GPF to the petitioner. As regards the leave encashment, the petitioner have not made any application for release of the leave encashment. However, the personnel department had requested the Accountant General AE to provide with the leave admissibility report for sanction of the leave encashment. The gratuity fund in respect to the petitioner have not been released due to pending departmental proceedings against the petitioner. And Rule 22 of the Assam Service Bracket Pension Rules 1969. It has been further mentioned that upon the petitioner being put under suspension, the department, by the communication dated January 2018 conveyed the sanction for payment of the subsistence allowance to the petitioner at the rate under FR 53 Roman main 53 bracket 1 bracket Roman 2 bracket small a, subject to production of certificate as required under FR 53(2) of the FRNSR. It has been further mentioned that on 26th of June 2018, the department had further, the governor of Assam had further conveyed the sanction to the payment of subsistence allowance to the petitioner until further orders, with effect from 14/12 to 2017 at the enhanced rate of 75%. Subject to production of certificate as required under FR 53(2) of the FRNSR. It has further been mentioned that the petitioner has been receiving the provisional pension. On the other hand, the senior counsel, Ms. B. Bhuya, had submitted that as per her instructions, the petitioner have not received any subsistence allowance. However, she has no instruction as to whether the petitioner had submitted the certificate as required under FR 53(2)
That is
of the FRNSR.
regarding leave salary, my lord, I've already preferred on representation of 5/6/2022.
It has also been mentioned that as regards the leave encashment, the petitioner had also submitted a representation on
On your lordship, it was received on 5/6/2022, wherein it has been stated gratuity, pension, ZPF and other benefits. Although specifically not named as leave salary, but it has been given.
Okay. No, then I won't. Let the matter be listed again on May 2023.
Lordship, may I pay month of April itself?
April, there is no time. That is the problem. No? The entire April, the first week goes, second week is only 3 days, third week is closed.
In March itself, your lordship.
March, too much.
On 10 days more only, 10 days more.
We'll have it on. You want April, we can give you on 28th of April, the last date. On 28th of April. On the same date, the learned counsel appearing on behalf of the accountant general shall apprise this court as to whether the payment, final payment for GPF have been already made to the petitioner or not. Further to that, the learned counsel appearing on behalf of the accountant general shall also apprise as regards the release of the leave encashment. The learned counsel appearing on behalf of the respondent, number 2-3, Mr. A. Chakraborty, learned counsel Mr. A. Chakraborty, appearing on behalf of the respondent number 2-3.
4 and 6.
You're not appearing for 4. 4 is final.
4, no, so no, sir. 6, Lord.
And
Sorry.
6 shall also apprise this court as to whether the petitioner have been paid the subsistence allowances pursuant to the sanction which have been granted as reflected in the instant order. The details in respect thereof shall be placed before this court. Anything else? Nothing.
Leave salary, leave encashment, GPF, GIS and all that, all the benefits, retail benefits.
GS, there's no mention about GS.
But I have made prayer.
The respondent the said respondent shall also, said the said council shall also apprise this court as regards the entitlement of the petition to the GIS. Accordingly, this court further keeps on record the instructions so placed by the learned counsel, Mr. H. Chakraborty, and marks it with the letter X. List accordingly.
Applied.
38.
এটা আছে, দুধ আছে তো। মুরগি। উনি বলছেন নটা আছে। Yes,
Hey, please, the matter pertaining to pensionary benefit and other retirement benefits. In this case, my lord, they have filed affidavit today, ma'am.
what have they stated?
They have only deposited an amount of 25,000, my lord.
How much you are entitled to?
But my lord, they have not mentioned anything about my lord, my gratuity amount, total gratuity amount,
What is your amount entitlement?
that they have not mentioned, my lord.
Have they denied?
No, my lord. My lord, page number 27, paragraph.
What is your amount you have claimed?
My lord, I have claimed for my lord, my regular pension and my lord, other pensionary benefits, my lord, gratuity and leave engagement, my lord.
No, what is the amount you are claiming?
That exact amount, my lord, as per my instruction, 7 lakh, something, 7 lakh.
Why haven't you written it out there in the petition? You want the court to make this assessment?
No, my lord.
Why there is not a single word out there?
My lord, after filing my lord, affidavit, I have
2 weeks granted to the petitioner to file the reply. You file your reply, state whatever amount.
applied to let.
39.
Yes,
To be related to suspension of the petitioner lordship. At page 45. lordship is under suspension.
affidavit has been filed.
Yes, lordship.
The filing reply?
No,
Okay.
because he is retiring lordship.
Huh?
He is retiring in this. month.
Mr. Counsel, I told you, you have to raise your voice. You are a fine counsel, but your voice is too meek.
Lordship, this is the second round of litigation, lordship.
Very
The
well.
earlier, the order, lordship, in WPC number 74H.
Chalo, we will have it on some other day. We don't see the AEGCL. Let the matter be listed immediately after Bihu vacation.
No, lordship, he will be retiring this month. such lordship, and
Huh?
He will be retiring this month itself, and if he-
Okay. Let the matter be listed again on 26th of April, no, on 29th of March 2023 at 2 p.m.
like,
40.
May I please address?
Hmm.
That is regarding non-freeze of provisional pension, my lord. Other personal benefits, my lord. Honorable Court directed lordship 6 February.
Yes, Mr. Sharma?
Lordship, if Lordship comes to page number 27, annexure 4. He has retired from Kasar, Lordship.
Yes.
He has retired, he was transferred to Kasar, Lordship.
Ah. Page 27.
Yes, Lordship.
Yes, what is it? Is it suspension?
Third paragraph, Lordship.
Period of suspension shall be treated as on duty as when on reinstating the services of the he is posted as extended.
If Lordship,
Qatar. Yes,
yes, Lordship. So Kasar is not under,
not in Assam.
no, not under Dimasa, Lordship.
So what? So it will be by which department? PWD. You are PWD, Mr.
No,
Solia?
Lordship, Mr. P Nayak is appearing lordship. He had to
leave.
Lordship, but I have the instruction, my
Very
lords.
well.
As per the instructions, my lords, the provisional pension papers have been prepared and forwarded to the additional chief engineer, my lords, on 13/3/23, my lords. So the case of the petitioner is being under consideration, my lords, but the provisional pension papers have not been finalized yet, my lord. So as this is the
What do you
instruction
understand by the word forfeit?
of it. No, no,
I don't know. The rule 22 says that everything says that forfeit the provisional pension and till the issuance of the regular PPO.
Yes, lordship.
And does it take 2 years for that?
Lordship, I apologize for that, lordship, but this is the.
I don't understand. Isn't it the requirement to immediately give the
Yes,
provisional pension?
Lordship, that I bow down to.
A person concerned, just for example, what was your salary when you retired? No idea. A person gets 1 lakh rupees.
Lordship.
From next day, he's zero.
Yes, sir. Lordship.
That is the requirement of a provisional pension, so immediately to be given.
Yes, lordship.
And for 1.5 years, he's.
Lordship. Lordship, there was a prayer petition from
Why
the.
didn't you do one thing? The government, let the government do one thing. The moment the person is going to retire, you start lowering his salary. And by the time by the end of the month, the last month, you don't give him anything.
Yes.
So that he gets used to it for another 1.5 years.
Lordship, the prayer petition also came from the petitioner on 20th of February, my lord. So maybe.
20th of February, does it have to wait for that? Isn't
Lordship,
it the requirement of
yeah,
law?
Lordship, I'm not. I apologize for that. Lordship.
Heard Mr. R. Majumdar, the learned counsel. R. Majumdar?
JU looks for it.
AU?
JU.
It's too late. Mosquitoes have started coming. Hello, I'll take up this is the last item. Huh? Mr. JUNM Laskar. The learned counsel appearing on behalf of the petitioner. Mr. A. Solia appears on behalf of the PWD department as well as for the finance department.
So finance department is not a treasury officer, my lord. That will be
Finance.
Lordship.
And Mr. C. Sharma. C. Sharma?
Yes.
Mr. C. Sharma, you were the person who appeared in those 2 suspension matters, no?
Yes.
Mr. C. Sharma appears on behalf of the NC Hills. Mr. R.K. Talukdar appears on behalf of the AG. And Mr. S.S. Roy appears on behalf of the government, on behalf of the Director of Pension. The petitioner hearing there's already a direction to pay the provisional pension.
Lordship.
On 6/2. Oh, we have to call this person then.
Lordship will have a short. Lordship will give me one short date. Lordship.
Let the matter be listed
Yes, lordship.
on 27,
Lordship. And any short date, lordship.
27/3/2023.
Lordship.
On which date the learned counsel appearing on behalf of the PWD as well as the finance shall apprise this court as to whether the directions in the order dated 6/2/2023 have been complied with by the respondent authorities for payment of the provisional pension as well as other benefits as mentioned in the notification dated 21/6/2012. List accordingly. I thought this was not done.